Hmm? Did you like?
Worship, yesterday I have been sent a communication that the matter is under examination and the ministry would require 2 weeks' time. So right now I do not have any concrete instructions of the issue. Worship.
Under the examination of the ministry,
Worship.
we report that
Yes.
postpone it for 2 weeks. I think the ministry's response should be necessary. This is done under them only.
Worship.
Mr. RKD Chaudhary, Deputy SGI, who appears on behalf of the respondent number A, submits that he has been verbally informed that the aspects specified in paragraphs number 7, 8, and 9 of the order dated 21/4/2026 is under active consideration of the ministry. And the ministry could provide inputs within 2 weeks' time. Taking into account the orders dated 21/4/2026 and 11/6/2026, wherein the court have categorically mentioned that the stand of the respondent number 8 would be of vital significance for the adjudication of the present dispute. This court directs the matter to be listed again on 6th of August 2026. Mr. R.K. Chaudhary, the learned Deputy SGI, shall duly intimate the ministry that the said decision be placed before the court on the next date.
Worship, I committed a mistake on the previous occasion. It would be the Ministry of Education. Now it is Education. Worship. It's not HRD. I have communicated with the Education Ministry.
The Ministry of Education. But yes, what has happened?
Sir, in this matter, we received the instructions and the financial section regarding the amount which is due to the petitioner that has been placed before the budget session which has been going on.
Budget session is over.
Yes, Lord. It has just been placed. I have just been told that it has been placed in the budget session, and it should be payable to the petitioner by the month of August, Lord. All dues. Yes, Lord. Yes, Lord. Telephonically, we have received that all the dues which are pending will be paid by.
There were several arrears which were required to be paid, in fact, last year also.
This has been informed by Mr. M. Mia, the Learned Standing Council of the Health and Family Welfare Department, that the areas payable to the petitioner has been duly placed before the budget session, and the said amounts are likely to be released to the petitioner in the month of August 2026. This matter on 7th of September 2026 for an update.
This matter Lordship, senior counsel Mr. Executive simply appearing Lordship. He is starting the severe criticism Lordship. In this matter Lordship, we have received the instruction recently Lordship, and we have prepared the affidavit Lordship. May kindly grant us 10 days time to prepare affidavit. Already prepared the affidavit. go inquiry lordship, the lordship has already stated that.
The affidavit which is required to be filed by the Gauhati High Court has not yet been filed. Mr. So-and-so, who appears on behalf of the Gauhati High Court, requests that the matter be adjourned today so that the opportunity can be given so that the Gauhati High Court is in a position to place its stand. He submits that the affidavit will be filed on
Lordship within 2 weeks, lordship will do.
within 2 weeks. Okay, list this matter again on 17th of September 2026. Interim orders passed earlier on 27/4/2026 stands extended until further orders.
Obliged.
Your matter. You do. You fix that too.
Our matter is 5. What do you, Jawan? As per our cause list, it is item 5, no? Yeah.
Item this is 6069.
That is item 5.
It's okay. This is so.
My lord, here in this case, my lord, they have filed this writ petition with regard to appellate jurisdiction so far land and revenue regulations, my lord. The BTC has passed its, my lord, the bill. And that is been subject to forward to the Assam government. And the Assam government has to decide it with regard to this. So may I pray that this matter may be.
That's a different thing. My
Yeah.
question is here, therefore.
Yeah.
As on that date,
Yes,
the settlement officer did not have the jurisdiction.
yes, no, absolutely no, my lord.
Lordship, that act is yet to come.
Yet to come,
Therefore, as on that day, there is no jurisdiction.
absolutely no.
So therefore, the order has to go.
Has to.
Yes, my lord.
That
That
will
is
be
true.
however the. Let us hear.
Yes.
Case, Lordship, there was a dispute between the petitioners and the private respondents, Lordship, 7, 8, 9. So our names were recorded over the plot of land. That is annexure 1, page 20. We were the
Let us read
Petition.
the order passed by me on 27/8/2024.
Lordship has raised an issue that whether secretary has the appellate jurisdiction to pass the order.
Because the jurisdiction would otherwise lie before the
Assam Land
Assam
Revenue.
level, Assam
Yes.
Board of Revenue.
Yes, Lordship.
So therefore, the order of the BTC secretary would be wrong. Unless there is an amendment to the Assam Land and
Land and
Revenue
Revenue.
Regulations.
Thereafter,
Because they can frame their own rules and regulations.
It's okay. See, the Assam Land and Revenue Regulation duly applies to the BTC.
Yes,
There's no quarrel with that.
yes,
Now, against an order of the settlement officer,
yes,
an appeal lies to the Assam Board of Revenue.
yes,
Now, there needs to be something culled out in the Assam Land and Revenue Regulation
my lord,
as an exception
yes,
by which the secretary BTC would have the jurisdiction.
correct.
But the secretary BTC jurisdiction is not there unless and until 147A
Yes,
is taken care of by culling out an exception.
yes,
That's
true.
the issue.
That's the issue.
Yes,
I think that I have duly recorded in my order of 27.
yes,
Yeah.
Lordship.
Yes,
And after
read it.
that,
I have-
after that,
I have to wait a lot of time. I have a matter at 2. I have a matter at 3.
Lordship.
No, all matters are getting adjourned. So I'll read my order on 27.
Lordship. Lordship raised an issue that whether without any amendment in the Assam Land Revenue, that secretary has any power to pass this impugn order, that is page 32. Lordship. 25/5/2022. Page 32.
No, no. Read the order of 27/8/2024. This is your base. This court by an order they can raise the question. Oh, here I raised that. Yes, 7/8 is the order. The instant writ petition has been filed by the petitioner challenging the order dated 25/5 to pass by the so and so, whereby the mutation granted in favor of the petitioners were cancelled on the ground that the deed on the basis of which the petitioner's name were inserted was a false document. Has been put to challenge on various grounds, including the ground that the secretary, land revenue, does not have the jurisdiction to pass the order dated so and so.
78, your Lordship.
Pursuant to the filing of the respondent filed the affidavit wherein various details have been given. However, it is relevant to take note of that the notification dated by which power has been conferred upon the director of land record so and so as well as the departmental secretary of the British. From a perusal of the day, it seemed that taking into account that the officers of the Deputy Commissioner and AI is kept outside the superintendence and control of the BTC. And as land and revenue are transferred subject, the power of the Deputy Commissioner provided under so and so was vested upon the director of so and so. This court, however, finds no fault in that aspect. However, interestingly, the appellate jurisdiction has been conferred upon the departmental secretary of the BTC. And in the instant case, the departmental secretary of the BTC in exercise of the appellate part. Question therefore arises as well, whether by way of a notification dated so and so, the provisions of section 147B, which stipulates that an order passed by the deputy commissioner or the settlement officer lies to the Assam has been amended. Pursuant to the order dated so and so, hearing produced the instruction issued by hearing. This court finds it very strange, taking into account that both the BTC duly admits the applicability of the Assam land and revenue to the BTC. But wants to include another authority in between the Assam Board of Revenue and the Director of Land. Question therefore has arisen as to whether by way of an executive instruction such a mode is permissible, that too when the Assam land and revenue regulation is a statutory enactment. Sir submits that he would take appropriate instructions. Today we have matter everything is going. Thank
19/8 also there is an order, Lordship.
Yes.
So far with regard to the constitutional provisions, there is no quarrel. That BTC has been formed, it will found place in the sixth schedule of the constitution and all. And thereafter, it's not been quarrel with regard to the provision of the sixth schedule itself. Wherein sixth schedule provides under paragraph 12 itself that all the rules, regulation of the Assam government or government of India can be accepted with modifications. That paragraph 12, this one. My lord, with regard to that, my lord, there will be modification from the BTC itself, copy that we are proposing. Now, this is in the tune of the memorandum of settlement, my lord, which is the memorandum of settlement found place in the constitution itself, my lord. In paragraph 20 of the sixth schedule, if your lordship.
Now let us see that notification of 3012, which was issued.
That is enclosed with the affidavit in opposition, lordship.
Page 47.
Page 47.
And this is the modification done by these notifications. What I am on, my lord, will kindly see. My lord, if your lordship, I can take your lordship to the sixth schedule. There are certain provisions which makes it different with regard to the administration of the sixth schedule area. Now, here, my lord, if your lordship appreciates that on the day when BTC has been formed, my lord, it is by way of a constitutional amendment. And in paragraph 20, if your lordship appreciated, paragraph 20 of the sixth schedule, my lord, what is the mode of, my lord, this whole amendment took place subsequently to the memorandum of settlement, my lord, that paragraph 20 of sixth schedule, my lord, tribal areas, down below, my lord, will kindly see the explanation part.
Yes.
Explanation part, my lord, may I read it, my lord? For the purpose of the subsection, the expression of memorandum of settlement.
Paragraph 20,
Pen the explanations down below, my lord, will kindly see.
where the
Explanation,
explanation,
5 explanation, my lord. Down below,
when did it come into? Paragraph 20 is tribal area.
tribal areas,
The
down,
area specified in so and so shall be tribal within the state of Assam and so. and
no,
so.
in
reference
between,
to
down, my lord. 1, 2, 3, 4, and 5, paragraph 19. And thereafter, my lord, will kindly see the explanation
when
part.
did this amendment happen? My book, I don't find it. Paragraph 19, transitional provisions.
My lord,
Only it has three.
my lord will kindly see this book, my lord. Yes. Down below, my lord. 1, 2, 3, 4, 5. Expression, this is there, my lord, Constitution 49 Amendment 1984. These are the amendments. And down below, so far with regard to 2003 Amendment Act, my lord, we can see the explanation. For the purpose of this subsection, the expression memorandum of settlement means the memorandum signed on 10th day of February 2003 between the Government of India, Government of Assam and Borough Liberation Tigers. Now, getting it. My lord, here, my lord, explanation, my lord, done. Okay, yes. So that memorandum of settlement.
Paragraph 19 has been amended in its application to the state of Assam by the sixth schedule. So as to insert after paragraph 3 the following subparagraph, namely paragraph 4.
So whole of the amendment is been basis is the memorandum of settlement.
So paragraph 4 has been
Paragraph 4, if your lordship comes in manner. These are administration of justice and in autonomous decision, autonomous. This is not applicable so far. BTC is concerned. This is not applicable. But if your lordship comes in down portion of 3B, these are the powers with regard to the subject that has been entrusted to the BTC.
19. Okay, paragraph 19 has been
Yes.
amended
Yes, ma'am.
in its application to the state of Assam by the sixth schedule to the constitution. With effect from so as to insert after paragraph 3, paragraph 4. Well, why it is given in the footnote?
It has been part of the constitution document, my lord, and that's been the basis of the constitutional amendment itself.
Well, understood, but why it is still in the footnote? Not in the body.
Not in the body, my lord.
Has this not been given effective?
My lord, this is the basis, my lord. Here, the
So as to insert after there the following paragraph, namely 4. As soon as possible after the commencement of this act, an interim care for the Iman shall be formed by the governor from amongst leaders of the borough, including the signatories of the soils, and shall provide adequate representation here, provided the interim shall be for a period of 6 months during the year. For the purpose of the expression, memorandum settlement so and so between the year. I think 4 no longer survives. Maybe because of that, it is no longer there.
my lord, what I am on is this, that because of the tripartite agreement between Government of India, Government of Assam and the then Borland BLT Tigers. Now, this has been the basis of the constitutional amendment.
Understood.
And if your lordship now look into the memorandum of settlement, now, right, that is there before your lordship. You can,
No, understood. But this is only for an interim measure.
yes, my lord, interim measure.
It is only for 6 months.
Yes, it is for the 6 month is for the purpose of holding general elections and all. So the election has been there, and thereafter elective election or election after election there is a government selected by the people at large. Now the basis of this constitutional amendment has been explained in this itself, the memorandum of settlement matter, and on that very basis,
No, there's no quarrel with that.
yes,
There is no quarrel with the fact that the BPC would have the power
yes,
to regulate all its things. There's
Yes.
no quarrel with that.
Yes.
I am not on that. Now, as regards the conditional provisions out here, 19. Let us
Yes.
take 19. As soon as possible after the commencement of the constitution, the governor shall take steps for constitution of the district council for each autonomous district in the state under their schedule, and until a district council is constituted for an autonomous district, the administrations of such districts shall be vested with the governor,
yes,
and the following provisions shall apply to the administration of the areas within such district instead of the foregoing provisions of this schedule, mainly. No act of the parliament or the legislature shall apply to any such areas unless the governor by public notification so directs.
yes.
And the governor in giving such direction with respect to any act may, direct that the act shall in its application to the areas or so and so apprehended and they have effect subject to such exception or modifications as he deems fit. The governor may make regulation for peace and here. Now we are on 19(1)(a).
Yes,
Okay. Now, if this document which you have given,
yeah,
public notice.
that has been adopted by.
No, this is the public notice.
Yes, under 12(1) of the paragraph minus section.
Now, understood. This public notice has to be, is in consonance with 19(1)(a).
19(1)(a) and with regard to the constitution, this constitutional provision under 6 schedule. Because 12, this is a notification under 12(1). If your lordship appreciate 12(1), my lord, it will be clear.
Yes.
Application of acts of parliament and the legislature of the state of Assam to autonomous district and autonomous region in the state of Assam. Now, so far with regard to BTC is concerned, my lord, it is exception to Karbi Anglong and NC Hills. These are also autonomous council, no doubt about it. But this is our hilly area. Now, so far BTC is concerned, it's plain area. So far with regard to the Karbi Anglong and NC Hills, my lord, the governor have the discretionary power. So far BTC is concerned, it's a constitutional governor, so far BTC is concerned. So all acts and all bills that has been passed by the BTC authorities has to be submitted to the Assam government. And Assam government, the moment it passes it, and that becomes a law. So the BTC has passed with regard to this particular law. And it has to be sent to the Assam government once.
See, you have to understand 12(1)(a).
Yeah.
No act of the legislature is state of Assam.
Yeah.
First of all, Assam Land and Revenue Regulation is not a legislation under of the state of Assam.
Yeah.
It has been made by the governor general in council.
Yeah.
It has been made by the governor general in council
Why?
in 1883.
Prior to independence.
Yeah. Okay. Therefore, for state of Assam, to be at one point of time, the state of Assam was the next by the 50 of the under 1856. The state of Assam should be regulated. First, where the land, second, where forest, in regards forest, you have initially the Indian Forest Act of 1865.
Right.
Then you have the Indian Forest Act of 1878. Indian Forest Act of 1878 was applied to the state of Assam. Right. Then, thereupon, what had happened is there were various rights in Assam which could not have been done so, or you could not have applied the central law. Right. Meaning that the Indian Forest Act. Yeah. So therefore, you have the regulation. These regulations have been made. One is the Indian Forest Regulation, which is 1892, Assam Forest Regulation, which is 1891, and this is 1886. Both of them came at the time, right, when the commissioner, the chief commissioner made a request to the governor general in council, particularly to the British Parliament. And the British Parliament ratified it, and thereupon the governor general in council made it. And it was notified as a regulation, therefore it is not an act. Yeah. This is done because Assam was born along the ruled as a chief commissioner. Yeah. It was never ruled as a part of the state of India. It was not a part of India at that point of time during the British. So therefore, you don't have the Indian Forest Act that 1878 thereupon applied. Right. As of today, also, you don't have the Indian Forest Act of 1927 applied to the state of Assam. Yeah. because of the fact that we still have the Assam Forest Regulation of 1891. Same here. 12(1).
Yeah.
A, apply.
Now, my lord will tell you, no act of the legislature of the state of Assam. That
Well,
is-
the state of Assam.
My lord is saying that this is not
Legislation only came into effect after 1940.
Yes.
After the constitution came
Absolutely.
into being.
right. My lord, the second part will tell you here. No act of the legislature said absolutely right. This is a legislation pre-independent. To any of the matters specified in paragraph 3 of the schedule as matter with respect to its district council. So the PDC, the settlement was 10/2/2003. Constitutional amendment is in subsequent date. And my lord, the Assam government follows land and revenue regulations. With regard to
No,
that.
therefore, by this notice,
Yeah,
the notice,
it's a notice required under
these are
12(1)(a).
orders made by the principal secretary, so and so, this is a notice.
Yes.
It doesn't have the air of the notification also.
No, my lord, may make rules and no act of the legislature of the state of Assam prohibiting or restricting the consumption of any distilled alcoholic liquor shall apply to any otherwise in the state. Unless in either case of the district or the district or having jurisdiction over such rule by public notification so direct. And the district council in giving such direction with respect to any act may direct that the act shall in its application to such district or region or any part thereof have effect subject to such exception or modification as it thinks fit. So three,
But
my
this is
lord,
for the state, legislation of the state.
Yeah.
Made by the state of Assam.
Yeah.
Assam Land and Revenue Regulation is not made by the state of Assam.
absolutely
So
right.
now we have to go, LEC B, the governor made by public notification, direct any act of the parliament or the legislature of the state to which the provisions of A of the subparagraph A does not apply, shall not apply to any autonomous area. So there has to be a notification giving a negative effect to a particular legislation.
Right.
Okay. Now let us come therefore to the transitional provision, because
Yeah,
here you
90.
see the last part of the public notice. So in view of the above, until and unless the Bodoland Territorial Council enacts any act or rule, etc., or pending approval thereof from His Excellency the Governor of Assam on the bill so passed by the Bodoland Area Legislative Assembly as provided to the transferred subject, the existing acts, rules, norms, guidelines, etc., except the reservation of so and so, and the rules thereunder, such as laws which are contradictory to the sixth schedule to the Constitution, shall continue to take effect, provided the then act rules so and so shall in its application have the effect subject to such exceptions or modification as the council thinks fit.
Yeah.
So therefore, the modification has to be made to the act.
Yes, that's true.
Okay. Now this act, modification cannot be done by the council on its own.
Yeah.
Without the concurrence of the governor.
But the governor doesn't come in because it's a constitutional set of this. So it is the Assam legislature who has the cabinet, my lord, who has to pass this one. After the BPP assembly has passed it one. That's the, my lord, interpretation with regard to so far BTC is concerned.
But kindly see 1918.
Yeah, that is conditional, my lord.
No, that is what I'm saying. We
Yeah.
are conditional at
Yeah.
that point of time when BTC came in.
Yeah.
Because you have to read 19(1)(a), read with the last proposition, portion of this notice.
My lord, this sixth schedule itself is a mini constitution within the constitution.
Understood?
So
Now therefore,
transition in a case wherein a new area under sixth schedule is being formed, there will be a transitional period. So, using 19 in isolation would very defeat the very purpose of sixth schedule, my lord.
No,
Because
no,
every provision has been made,
No,
that
I'm
the
not-
power and
I am not on that. I taken it, very keep 19.
Yeah.
1(a).
Yeah.
As soon as possible after the commencement of the constitution, the governor shall take steps for constitution of the district council for the each autonomous district in the state under the schedule, and until the district council is so constituted for an autonomous district, the administration of such district shall be vested in the governor. Meaning thereby, in what has happened in this case, if you see that amendment to 4, the
Yes.
clause 4.
Yeah.
Instead of the governor being given a power
Right.
to rule on its own,
Right.
the power has been conferred upon an interim council
Right.
for a period of 6 months
Right.
till the formation of the district council.
Right.
Now the district council has now been formed.
Right.
Now what happens? And the following provisions shall apply to the administration of the area within such district instead of the foregoing provisions of the schedule mainly. Because here it says, this is only for that transitional period.
Yeah.
Till the formation of the district council, because the laws are to be made by the district council.
Yeah.
So till the formation of the district council, the interim council, which is not otherwise here.
Yeah.
Or the governor
Right.
shall follow the same laws which are there.
Once a selective government comes in, minor, they can have their own.
They will make their own laws
Yeah.
because the power has been given to the regional council to
Fine.
make the laws.
Absolutely.
Okay. So therefore, this is only for that period of 6 months.
A minor transitional provision. Yes.
So 19 will only apply for a period of 6 months.
Fine.
Thereafter, the governor, the regional council will come and step in.
Absolutely. And the other paragraph with
Now,
regard
let
to
us
district
see-
will come into.
Now let us see now 12.
12.
Because here 19 makes it very clear instead of the foregoing provisions of the schedule. Meaning thereby, paragraph 19 is an exception to the all other provisions.
Yeah.
Only during this period when the governor rules and in
Yes.
the instant case when the interim council rules.
Right. Absolutely.
So now let us come to 12.
Yeah.
Notwithstanding anything in the constitution, no act of the legislature of the state of Assam in respect to any of the matters specified in paragraph 3 of this schedule as matters with respect to which the district council or the regional council may make law. Now you have the power to make laws on land.
That is the paragraph 3B, that was by an amendment, it has been inserted and BTC has come
Yeah.
up.
May make law. And no act of the legislature of the state prohibiting or restricting so and so shall apply to any autonomous district or autonomous regions in the state unless in either case the district council or such district or having jurisdiction over such region by public notification so direct and the district council in giving such direction with respect to any such act. Direct the act shall with application to such district or any of the part thereof have effect subject to such exceptions of modifications as in bid. Now, this is the public notice.
Yeah.
This is the public notice we are speaking
Of 2010.
This is the gazetted notification.
Yeah.
Now, what do you say about 47, page 47 of the page 47 of the affidavit? This is the notification.
This is of 2016, minor. In all fairness, I will submit report is available for. Now.
This
whether-
cannot be a public notification.
No, it is not. It is not. First of all, second thing, my lord, with regard to the BPC having power to legislate, a decision at least to be backed by the executive council, that's the cabinet, has to be there. Now, that instruction I'm awaiting, my. If it is the backing of the EC, the executive council, and thereafter, my lord, this notification has been issued, my lord, then the things is different. But if he doesn't have the backing of the EC decision, and apart from the subsequently, my lord, they have drafted their rules, passed in their assembly, and it's been pending, and it will be subject to Assam government decision, my lord. That would be, my lord, crystal clear. That's why I pray before the honorable court to accommodate me to that extent, written instructions specific, whether this notification is backed by EC decision or not. They have conveyed me, my lord, unofficially, but that I do not want to say and submit because it will be a matter of record then. I need it in record, my lord. Otherwise, my lord, the consequence is, my lord, very high.
But whether you see, when it says
Yes,
by way of a notification,
my lord.
it can go away.
Yes.
It can take away. Can you say the page 47, even if the EC says so
My
as
lord.
a notification? Unless it is.
Therefore, the council, head of the department, director, regarding land, right notification dated. They are relying on the notification
No,
of
it's okay.
2004 of the Assam government.
First of all, Assam government has no business.
No, man.
This has to be done by the regional. The regional
true.
council.
That power has been given to the by Assam government by this notification.
No. Let us see the constitutional provision. It
Yes.
says, no act of the legislature of the state in respect of any matter specified in so and so. As matters with respect to the district council or the regional council may make laws.
That's true, man.
And no act of the legislature of the state prohibiting or restricting the consumption of any non-distilled alcohol so and so shall apply to any autonomous district or autonomous region in the state. Unless either case the council.
Yeah.
Or the such district or having jurisdiction over such region by public notification.
Man.
So that, so unless in either case, the district council.
Right.
For such district.
Right.
Means you may, for Udalguri, you may have a district council.
Yeah.
For Pirang, you may have a district council. So that, or having jurisdiction over such region.
Right.
By public notification. So that, and the district council in giving such direction with respect to any act may direct the act shall in application to such district or region or any part thereof have effect subject to such section or modification as it thinks fit.
So
Now,
power is given to the BTC as it thinks fit, provided it is as per law. Now, my lord, the constitution memorandum of settlement.
now tell me another thing. How does the BTC territorial council gets the jurisdiction?
So, my lord, first thing first, my lord, the background with regard to this is this, that there were disturbance with regard to political and social right. Now, Government of India comes up with memorandum of settlement that form part of the constitution and be recognized in the constitution. I have shown it, my lord. Then this has been placed as a bill, my lord, that BTC will be formed and will be part of the sixth schedule of the constitution. Now, there is a difference between the sixth schedule area in Assam in other areas and in BTC. BTC is concerned, it's a constitutional government, my lord. That is the Council of Ministers, my lord, and it is under them, my lord, directly. Whereas, my lord, other are discretionary power of the governor is there. Now, once the constitutional amendment has been gazette notified, my lord, thereafter Assam government came in with the office memorandum dated 16 October 2004, my lord. Can you look into it, my lord? That will be in the book, my lord. And there is, my lord, with regard to the notifications, my lord. If I take your lordships to the constitutional provisions with regard to memorandum of settlement, that will be clear, my lord. That is the basis. That they intend to, my lord, delegate the self-governing power to the area which is been recognized as BTAD, by Borough Territorial Autonomous Districts. Whether, my lord, the memorandum of settlement is been there.
I'm reading it.
Yes.
when we come to the memorandum of settlement. Yes. Here you see some power here. Please see to the PTC. Five point one. Yeah. The council shall have the legislative power in respect to subjects transferred to it as enumerated and
Annexure three.
Extra Roman three.
Yeah. That is
All
3B of the-
laws made under this plan.
Yeah.
Shall be submitted for fit to the governor.
Yeah.
And until extended to him.
Right.
To
Shall not
which
come into force.
shall have no effect.
Yeah.
The PTC shall have executive, administrative, and financial powers in respect to the subject transferred to it.
Yeah.
Now, therefore,
Annexure three, my lord, you can use that.
no, therefore, the serial number 25.
Yeah.
Of Annexure 3.
Two, land and revenue.
So land and revenue will come in.
Yeah.
But it has to be, have the concurrence or assented by the governor.
My lord. Now, my lord, will kindly come to the Assam government, my lord, notification. Thereafter, my lord.
Which one?
Yeah, I'm coming to it, my lord. First, my lord, may I take your lordship to page, this is a different book, but anyway, my lord. This is with regard to 7 September 2003. This is Gazette of India, my lord. Gazette notification of Government of India. Where is that? I have that with me.
Annexure four.
Huh? My lord, so far with regard to the provisions with regard to the sixth schedule that has been notified. Another notifications, my lord.
But it means,
Yeah.
the power which is being given to the BTC.
Yeah.
Is different from the power which is again given in the sixth schedule and the 12th.
My lord, the power that has been given in 12. 12 is so far with regard to my lord application of the Indian government laws and the Assam government law.
Now, Indian government laws, no, there's a difference of.
Yeah.
Indian government laws will automatically apply.
It is not, man.
No,
Unless adopted by.
no, no. If you see 12B. 12A, small a shows only the legislature of the state. Only see 12B. It doesn't say anything about
Any act of parliament or of legislature of a state of Assam to which the provision of clause A of this chapter do not apply. Cannot apply to an autonomous district or an autonomous region in that state and shall apply to some different region or any part thereof. Subject to such exception or modification as he may specify in the notice. So this is with regard to the Indian government laws with modification also we have the power.
you have the power
Yes.
to apply.
Yes.
But there has to be a positive act
Yes, that's true.
to the effect that the Indian laws would not apply.
Yeah.
Or Indian laws will apply with such modification.
Modification.
So therefore, that is why the legislature, the constitution has made two provisions.
Yes.
12A for
And-
only for the legislature of the state.
Yeah.
12B
Is
for the legislature of both. But in
Absolutely.
12B, the governor is required to issue a notification.
Yeah.
Whereas 12A, the power is being given to the district regional council.
Yeah.
The governor has no role. 12A.
so far.
So therefore, here, the memorandum of settlement, more particularly clause 5.1,
Yeah.
is in deviation to the laws which have been made in 12A. How does it show about all other lands? Shall have the legislature have the power to hear until and assented. Now, this is the power of legislation.
It provided as 12.1.
No, no, 15.5.1 of the MOS
Yeah, it's not been put,
is the power to legislate.
Yeah.
It's a power to legislate.
Yeah.
Not the power to apply. There's a difference of.
minor to all my limited knowledge with regard to constitutional, interpretation with regard to this. Is that application will come that way. But with regard to the modification power that has been inculcated in the sixth schedule provision itself, and they have the power to modify that.
So therefore, my question is 12A categorically empowers the regional area, regional council. Kindly appreciate one thing. 12A is not amended by the MOS.
No,
MOS remains as it is.
yeah,
So in the MOS, 5.1 is the power to legislate.
right. Yeah,
5.1 is the power to legislate, and when such power is being exercised to legislate,
Yeah.
that power is subject to the assent of the governor.
no, that's
This is the
Yeah.
power to legislate in respect to all the
subject.
subjects which have been mentioned in Schedule 3.
Schedule. And in the constitution, paragraph 3B.
Understood? So
Therefore, government of Assam is
Where is-
notification.
no, whereas paragraph 12 is application of the laws,
Yeah,
existing.
Yeah.
So application of the existing laws is different from the power to legislate.
yes. These are two different powers.
Different.
Yeah.
Now, this power under 12A is given to whom? Shall apply to the autonomous council unless the district council or such district or having jurisdiction over such region by public notification or directs.
Right.
So the district council for such district.
Right.
Now, how does the Boroland, again my question comes back to, how does the Boroland Territorial Council gets the jurisdiction?
It's the jurisdiction because of the constitutional amendment. It became a constitutional document and the
No,
Assam-
understood, but as regards application of law.
So the Assam government minor, on the basis of constitutional amendment, there is an office member in the minor. I have to say, and it ought to have been given minor, everything minor, so that. Yeah. Yeah. Assam Gazette notice minor, that is on 30th October 2003, which is Assam government Gazette notification. Consequent to the Gazette notification 48 September 2003 issued by Government of India, amending the sixth schedule of the Constitution, the Governor of Assam is pleased to reorganize the district of so and so, 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 minor. This is the notifications minor.
You are referring to the 16th October 2004.
The 16 October 2004 minor is a different document.
Is an office memorandum. Which memorandum is what?
That is office memorandum, minor, on the basis of the Governor of Assam's notification is minor, 30th October 2003. And provide all such book minor, similar books, so that it can be easier for the court and we can deliberate on it matter. And provide all the notification with regard to this one. The office memorandum is 16 October 2004, minor than 10. This office memorandum recognized with regard to the memorandum of settlement, and it refers to Assam government 31st October 2003 adopted and approved a aforesaid MOU resolved to extend activity powers.
So this office memorandum is in view of the memorandum of settlement.
And the constitutional amendment.
Constitutional amendment happened later on.
Yeah.
The memorandum of settlement categorically says, if you see the heading of Schedule 3 of the memorandum of settlement.
Yeah.
See the heading.
Memorandum. Ready.
Heading.
Yeah.
Subjects which are transferred to the BTC.
Yeah.
See.
Yeah.
Now what has happened? It is something like this. To give a metaphor to this, it would be something like the Panchayat Act.
Yeah.
Now, Initially, what happened, the entire act or the functions were done by the state. Now, for the purpose of local self-government,
Devolution of power.
this is being devolved by the state. So therefore, here, in view of the memorandum of settlement, this MOS has to be MOS. The office memorandum has been issued on 16th of October
That is
2004,
constitutional amendment.
thereby transferring these subjects
Yeah.
to the
BTC, my lord. BTC. My lord, first memorandum settlement, then constitutional amendment,
but
then this one.
But my basic question again falls back.
My
How does the BTC, can the BTC be conferred with the jurisdiction by the state for application of laws?
my lord.
There the problem lies, because when the constitutional provision says it is given to the district council,
Yes.
to the district council of concern with the district, unless there
It
is that gap.
It is the combination of several autonomous district councils.
So that has to be somewhere, there must be some document by which the district council of various districts
Yeah.
forms or is being recognized by way of a constitutionally recognized document.
Yeah.
Today, the state of Assam has no business law.
My
Therefore, why the memorandum of settlement had to be entered by the Union of India? Because the Union of India would have the power.
that's
So therefore,
the-
there has to be somewhere the BTC, the district councils of various districts.
yeah.
Because here we have four.
Code.
You see, this was being conceived up as regards in the state of Karbi Anglong. Now, Karbi Anglong at that point of time had one.
What?
NC Hills had one.
Yeah.
Now, this problem will arise now. I don't know how they have dealt with that because now Karbi Anglong has been bifurcated into two.
Yeah.
Now, with the bifurcation of the two, how do you deal with 12A?
12.
Here, the use of the words is very difficult. Unless either case, the district council for the such district.
Yeah.
Or having jurisdiction over such region by public notification so that. So how do you bring these four districts, the district council of four districts, under the BTC, to exercise the power under 12A?
Now, for that purpose, my lord, before forming it, my lord, there are, my lord, with regard to the governor, this is the power being provided in the section itself. Petition of village, subtraction of village,
Everything is possible.
and what is the requirement with regard to the, what are the principles to be followed, contiguity of village, whether 50%.
You kindly see this, kindly come to chapter, the table.
Yeah.
The table of the Sikh schedule.
Yeah.
When a Sikh schedule was made.
Yeah.
It was one district.
Yeah.
Table 1, North Kachar Hills district,
That's true.
Karbi Anglong district,
Yeah.
Boroland Territorial Area district.
Yeah.
So therefore,
Area district.
this is somewhere defined somehow. Number 9 is somewhere defined as what is the Boroland Territorial Area district. It is.
Yeah.
It is defined anywhere.
It's defined by.
Where? Then you may get therefore, it loses the significance of that.
My lord, will kindly come to the amendment part, paragraph 1, minus 2003 Amendment Act. Where nothing in the subsection shall apply to the Boroland Territorial Area District. So this is an exclusion one.
Understood.
Yeah.
My question therefore is, where is that?
Paragraph 1, my lord. Paragraph 1 has been amended in its application to the state of Assam by the 6th schedule of the Constitution Amendment Act 2003. Section 2(1), with effect from 7/9/2003, when this BPC has been formed by constitutional amendment. So as to insert after subsection 2 the following provision, namely, provided that nothing in the subsection shall apply to the Boroland Territorial Area District.
Provided further that any order made by the governor on the plan of the area.
There is an exception been provided so far, this is concerned.
Where I'm not getting one, paragraph one,
Paragraph one, my lord, exception has been provided, my lord.
where?
Uh,
Provided that no order shall be made by the governor on the CEE.
Here, my lord, you can. Yes,
Again, you are going there.
yeah,
Where?
because it's 390 page, my lord, 4 my. Paragraph
Has been
one.
provided- Paragraph one has been amended in its application in the by the sixth schedule of the month, so far provided that nothing in this subparagraph shall apply to the PPD.
So this is an exception to the Karbi Anglong and the NCL.
But why again it is not found in the body?
Yeah.
No, there's a reason, must be a reason why. Why is it not found in the body? Ah, if there are different tribes in any autonomous district, the governor may by public notification divide the area or areas inhabited by them into autonomous regions. Okay. But I think mostly this is some amendment. Provided that in its application to the state of Assam by the sixth schedule to the Iman amendment, so far as insert after paragraph two,
Yes, paragraph two. is
the
referred to
following,
the-
because it is not required.
Yes,
You see, therefore now it gives a reason. One, you see, two, if there are different scheduled tribes in an autonomous district, the governor may by public notification divide the areas or areas inhabited by them in the autonomous region. Okay?
Yeah.
Now, this would not apply in the BTD. No, that is okay. Now, why the BTD area has been defined somewhere?
yeah,
Where?
that for my lord, under this.
The
and
Borolan territorial
Minor-
area district. Because then it gives the significance to 12.
Yeah, why not? Under the sixth schedule itself, my lord, with regard to the state of Assam or any new state has to be created. Now there has to be survey and all such things has to be done. Now in this particular, this also, my lord, exercise is being done, my lord, and that can be done and provision is been also there with regard to that, my lord. I'll come to that. And the paragraph two, my lord, have gone to it, my lord. Kindly see paragraph two, four, subclause four. Subject to the provision of this schedule, the application of an autonomous decision so far is not vested as whether this schedule with any internal council within such district be vested in the district council for such district, and the administration of autonomous units shall be vested in the regional council for such region. By in an autonomous district with regional council, the district council shall have only
No,
such
but
power.
this
with
is,
regard to
you
PTR.
say, you see that the BTC is the BTC.
Yeah.
Is a regional council.
Yeah.
Then the problem arises that 12(1)(a) does not say about the regional
No,
council.
minus it is Roland, areas.
Therefore, it
That
has
area
to
has been
be,
demarcated.
it has to be mentioned that the entire 4 districts will be one district.
Fine, it is autonomous districts, my lord. And for the purpose of Assam election, it will taken in a different manner. For the local election, it will different manner.
No, it's okay, I'm not on that. Therefore, in order to apply 12(a),
Mine,
it has to be only by the district council.
mine. And
It
that
is not the regional council.
no, and so my lord, this is.
So therefore, BTAD has to be construed to be one district.
One state like one district.
It is one district.
Yes.
And that the BTD, the BTC becomes the district council.
Autonomous district.
It is a district,
nomenclature.
it's the concern to be district council.
Yes,
Because in order to apply 12A, it has to be the district council.
Right. And the minor power.
Because 12A is not empowered to give it to anybody.
Yeah.
Now, tell me, if that be so, by way of a public notification,
Right.
this can be done.
Yeah.
That power can be exercised.
Yeah.
Now, can this notification be issued in a manner in which page 47 has been issued?
That's
A
right.
notification has to be gazetted.
Yes. Gazetted backed by a decision-making process. by
That's
the-
okay. That's another aspect.
Yeah.
Whether there is a decision-making
That's
process or not. Now, therefore, to give an appellate jurisdiction from that of the DC.
Yeah.
The DC has been made the director of land records.
Yeah.
For giving an appellate jurisdiction from the DC to the secretary.
Right.
There cannot be a further appeal to the Assam Board of Revenue.
Absolutely.
Because there will be the full review. Because if you see,
Yeah.
on the earlier occasion when you were not appearing, Mr. Expired, the earlier council had expired. So his submission was that, look here, this secretary, beyond the secretary, there is an appeal lies to the Assam Board of Revenue. Then it caught my attention that can there be a four-pronged attack? The four-pronged, first you have the circle of Assam. Then you have the DC. Then you have the secretary. Then you have the Assam Board of Revenue. It cannot be. So therefore, it cannot be to the Assam Board of Revenue. Now, are you replacing the Assam Board of Revenue? Now, if that be so, it has to be by way of a public notification.
Yeah.
And this cannot be a public notification. And if this cannot be a public notification, then the matter falls on this aspect itself.
I have to assume this much further. If it is not in accordance with law, I have nothing to say, but that inspection is required. That whether with regard to this particular notification, any policy decision will be taken with regard to this by the assembly or the executive council of PTCL. If it is not by law, it falls flat. Apart from the requirement of gazette notification. May I pay for accommodation for 4 weeks for the time? I pick up this matter so that this forget. I'm just folded and I can say, I didn't see a lot.
No, I think this is but what done here. I need to just find the link. How BKD became.
I'll hand over a book, my lord. I'll try to find out, my lord. All rules, regulations, everything is good there.
The rules regulation is different, but
Government of India
it
is
has to be
documented, my lord.
recognized by way of some constitutional document.
Yeah. These are all the.
Now, because you see, the MOA does not say about BKD, because
That was asked by the. Festival, yeah, he talks about the Board and Territorial Council.
the proposed BKD will comprise of all the related Mr. One.
Yeah.
So it says about the above mentioned related things divided into four particular districts of the 12. So here is the concept in BKD. But in BKD, how does the government territorial autonomous district come into being? Somewhere down the line, somewhere it needs to be there. Why the constitution does not use the word BKD? Yes, why?
That I have to say, yes, that's a very relevant.
Because then it gives the jurisdiction of the 12A.
Yeah, correct.
Then it becomes the jurisdiction. Otherwise, Iran district council will be there. Fine. That's Iran has a district council.
It's just a district.
So therefore, all four will culminate or combine together.
Yeah, within the BTA.
So somewhere something, because the MOS is silent on this.
Yeah, I will check it out further. That's a very relevant and practical thing.
So then it becomes a district council and then the question is, railway, it may be continued to be a notice, notification, whereby it says that it will apply. But can we, 47 be the basis? No. Then if 47 cannot be the basis.
Already feeling that I find another way to And in that petition, they have already filed application in opposition saying that. That is 2024. That is pending before December. Not sure, I have, paid for-
request for selling?
I have paid. Then so that both can be decided to use on those. Then what happened? Then it does not allow.
We have found out for the the reporter can send this matter to the DB. Let the DB decided. They're so happy enough to think they are. We need to discuss more restitution or allow more restitution quickly so that I think they have less of matter.
Already there was a stand taken that they are going to enact a law. So.
Never the enactment of law. Enactment of law also. See,
Lordship,
at that point of time, it cannot be given retrospective effect. Jurisdiction has to be controlled, cannot be given retrospective.
So, Lordship, in that way also this notification will take Lordship. And if you
I
order
agree
which
with
was passed is required to be set aside on that ground also, as they already admitted that they are going to enact a law and.
But they have already passed in the assembly, that is.
Yeah.
And it is subject to place before the Assam. That's it.
It is also pertinent to mention herein that the BTC has forwarded the bill, Borough and Territorial Council Land and Revenue Regulation Application and Amendment Bill 2024 to the Commissioner and Secretary to the Honorable Governor of Assam, Raj Bhavan, Gauhati. By this Secretariat letter memo number dated 3/2/2025. It is further stated that until and unless His Excellency the Governor of Assam assent to the bill will have no effect and therefore the BTC cannot exercise its absolute powers on land matters, which is an entrusted subject to the council authority. So it is already admitted. Therefore, I prayed on last occasion to take up this matter after some time so that I can pray for the division bench to refer that matter also to be decided by a single bench.
No, no, no. I allow you to. You know that other one. Correct. And the court will once a disposal, the decision.
they are already admitted.
Give him a decision, give the decision on the disposal by withdrawal.
This was filed on 27/3/2022. It is already on record.
Therefore, he get to insist on this. No need to challenge the notification. I mean, what is the view of challenging this notification?
Lordship, an objection was raised on last occasion that we have not taken the classification. So as per that classification, the secretary has the power to decide.
And first of all, I don't understand why this to be. This is
This is a color of an X lordship, so it will be identified.
Or even. When that too it has not been. We just find out that whether it has been. Yes, I get it. I will. Let it come next week, my lord. Can we find it out with finish? Yes.
If your lordship allows me, then I can file an additional affidavit by changing on record.
This court had been heard. The art must so the limit to make out to by hearing on behalf of the. Your DPT.
I will not make the mistake.
Who appeared for the private respondent? You. You. You are? They appeared for the private. This court have heard the learned counsels at length. And upon hearing the counsel, this court has proper instruction from Mr. A.K. Bhuyan, the learned senior counsel. As to whether the
12,000. I think 12,006.
Whether the document in the name and style of a notification dated 30/12/2016 issued by the principal secretary P have all been gazetted. The 11th, the council is also further directed to examine as to whether the said notification can at all be paid to be a public notification, which are the words used by the words used in paragraph 12, small a of the 16 to the constitution. Because they use the word
Yes.
public or very, it doesn't say notification. Absolutely. This is matter again in next week. 28th of July. The 28th, 20, my lord. Two. The proposal. And then Mr. Bhaiya, you kindly give me the other thing. Yes. And then you can take this MOS, you can take this MOS and the other and give me a compilation of that. Everything I compile. Made it a previous paragraph 16 of the restriction. The answer is dependent to state that the respondent number 6 and 7 have fulfilled the mandatory provision as prescribed under section 42 of the Act, as they have attended more than two AGM in the previous 5 years from 2016. Previous 5 years, according to him, my lord, start from 2017. In paragraph 16, sorry, I refer to paragraph 16 also. Paragraph 16. The statement made in paragraph 15 of the petition, the answering dependent back to state that the respondent number 6 and 7 have fulfilled the mandatory provision as provided under section 42 of the Assam Property Trust, as they have attended more than two AGMs in the 5 years current. So, since the AGM of Tengadpur Samavaya Samiti was not held during 2019-20, thus the disqualification under section 42 of the Act for not attending at least two AGM in the previous 5 years cannot be placed into service. Thus, the complaint of the petitioner against respondent number 6 and 7 does not abide the Assam Property Trust Rule. So, according to him, my lord, for not holding the AGM, my lord, the benefit was given to the respondent number 6 and 7. I think one. Yes. Now, he says that there is more than two AGMs in the previous 5 years from 2016 to 2018. Yeah. 15, 16, 16, 17, 18, 18, 19. Yes. So till there for 4 years. The 4 years he has participated for two. Yes, it was my lord. We have also participated in the SJM held on 2019. 1 week. Previous 5 years, he attended only 1 week. Only one. You attend from 2015-16. Yes. We have attended 2015-16. Thereafter also we have attended 2 years. My question is simple. From 2015-16 to 2018-19. Yes. There are 2 years. 15-16, 16-17, 17-18, 18-19. Would you attend for 2 years? Where? Madam? Okay, got phone number 6, my lord. You have filed your affidavit? Yes, sir. 1819. 1819. Okay. What is the name of the number 6? Respondent number Parekh. Abdul Parekh. Where is his name? At page 140. Nothing like this, he says
55, serial number 293.
This is Abdul Barik. Now, he response number 6. This is for which meeting? This is for
Of 2027, 2017.
it is for 1718. 17. Huh? 27. So this will be 1718. So 1718 response number 6 is part 3. Then 7 is the button. Huh? 7 is 8, 78 left.
Serial number 840. 849.
A Khatun. A or S Khatun.
A Khatun, Marathi.
It is participating. It's for 1718. What is 1819? Or 12, 15, 15.
That is 155.
Huh?
Page 155. 155. This is the color 2019.
Huh? 165.
155. Page 155.
Serial number
Serial number 150. Danara 150. 150. Danara Kotorapodorali.
and the other one
155. Abdul Barak Kusum.
155. Abdul Barak it has been struck off. Huh? Why is it struck off? Anyway, it is being signed by whom? Who is signing here?
By the
155, it is Abdul Barak. Then the next name is whom? In Ali. Well, what are the things? What are the 5 names for? 5 columns for? Corner. What is your father's name? Abdul Barak's father's name? Mana?
Hussein Ali.
Hussein Ali. And why the sign is by somebody else? Joina, what is his name? Fine. Abdul Barak's signature is Joinadin. What? Earlier you have put your left thumb. Did you get educated in 1 year? Put a signature. What? Whose signature is this? 155. Whose signature?
That is different.
But then,
My lord, paragraph 11 of the respondent number 2, let me repeat my word. That makes everything clear. Paragraph 11. Of the respondent number 2, the petition. Is the authority, my lord, register?
during the previous 5 years, only 3 AGMs were found to be held.
Yes.
First AGM on so and so for the year 1718.
That makes it.
Second, 18, 19, third, 1920.
We have submitted an additional. For the was found to be failed. The respondent number 6 was not found to be present in the AGM 2018 and 2019. And respondent number 7 was found absent on so and so, so and so. So out of 3, only 1 meeting he attended. Both of them attended. That is the fact of the matter. Here in paragraph 2. Clear? And the period is from which period to period? 2023, 24 to. Yes, 5 years from 2017, 18 to
17, 18 onward. 17, 18 onward, 18, 19, 20, 20, 21, 21, 22.
5 years, previous 5 years, up to 20.
But we are not concerned with 2015, 2016. But that part of the affidavit is wrong. So it is from 17, 18. So 17, 18, for the year, previous 5 years only, 3 ATMs were found.
Yes, sir. The
First
AGM was held on
17, 18.
yes, 27, 2017 for the year 17, 18, the first AGM was held. Then the second AGM was held on 39, 2018 for the year 2018, 19.
17. The second is 39,
2018
2018.
for the year 2018, 19. And the third AGM was on 19, 9, 2019 for the year 2019, 20. Then because of the COVID pandemic, the 2021, the 2022, the meeting was not held. And the last AGM was held on 27, 8, 2023, where the resolution was taken for the election.
Now, 19, 9, 2019. Either for 2018 and 19, 20. 19, So 17, 18, who was present?
17, 18, actually, as per my application, number 171. Contact number 6 was found to be present in the game dated 39, 2018.
Phone number?
6.
6. Okay.
39, 2018 and on 19, 9, 2019, your lordship.
That's phone number 6.
That's one number 6, your lordship.
Okay.
The respondent number 7 was found to be absent.
Present. Let us go into.
He was present on 39, 2019.
Only one.
One.
So therefore, it is one.
One.
It's phone number 7.
7.
Now, 2 years it was not.
2 years ago.
Now, he is the shareholder. Or a direct.
Shareholder, now direct.
Now, for 2 years, there was no meeting held.
Yeah.
Now, let us take the example of a meeting not being held for 5 years. Yeah, good. No. Can a shareholder be right of participation
From contesting.
because of the fault of the direct? Because it has to be it has to be done by the cooperative society, the direct.
Yes.
And the elections are to be done by the society under 41(2), 41(2), yeah, 41(2), 41(2). So therefore, if these are not being held, can the shareholder be penalized? That is the issue.
That is the issue. Yes, ma'am. If relaxation is there, but section
What are
40,
relaxation under 138? 138, relaxation is only for what? That you are allowed to postpone it by 6 months.
yeah,
That's it. Nothing more than that.
yes, 40, 39 and 41.
41 to
Yes,
41 to elect.
election.
39 is you have to hold the AGM every year within 6 months from the end of the financial year. That means by 39,012. You have to hold. That is the law. Now, if the AGM is not held, can the shareholder be penalized? That's the law.
That is why, my lord, previous 5 years, not 2 years. Previous 2 meetings.
Understood. Maybe 5 years.
That is
So there were 3
3 meetings. He could have attended 2 meetings.
He could have attended these 2 meetings. But he could not because of the fault of time. Can he be in it?
Other shareholders of this cooperative society were permitted to contest this election. If he, my lord, approach this honorable court at the relevant point of time.
16/8/2023. You are referring to this.
At page 170, eight lord. Paragraph number 19. The purpose of the order dated so that the board was dissolved for not holding an election for the year 2020-21, meaning that the election of the cooperative society was required to be held for the year 2020-21 within the outer limit of 30th September 21. And the financial year of 2021 would be from first day of April 2020 to 31st March 2021. However, the provision of section 39 of the Act 2007 was applied and the board wherein petitioner were directors was dissolved. This board cannot also be unmindful of the provision of section 130A of the Act of 2007 as well as the various restrictions so imposed on the account of COVID for which admittedly the state of Assam is granted exemption from the operation of section 39 and 41 of the Act 2007 as regards those cooperative societies who approached the government claiming benefit under section 130 of the Act of 2007. The court further finds that it relevance herein to observe that a pursuant of section 130 of the Act of 2007 does not postulate the necessity of filing application for claiming benefit in the circumstances of the present kind wherein there was existence of lockdown restrictions on account of COVID. Now can the page 151, paragraph number 26 and 27. 26. Under such circumstances, this court disposes of the writ petition with an observation that the petitioner cannot be disqualified if they submit their nomination of the degree on 48. 42 different. We are on 42, my lord. 42 not conducting. This is for those director. Director. That is why I don't remember doing anything on 42. Yes. We are for the director, they could not hold it. For those because if you can't hold the meeting on a particular day, then you are at fault. Because here, this I followed it with the question. Another subsequently also I passed another. When was the manual bill? This is of my lord 2022. 2022. 23, yeah. 26 also I followed another judgment recent. I think just before the vacation I passed one on. Where I said again 44A and 44E would not apply. More particularly in respect to an election. Because there if the steps were being taken by the society for holding the election, but the elections could not be held on account of the fault. So the fault attributed by the respondent, official respondent. No, the fault attributed. What has happened? The register register held that they are not disqualified. I thought following the judgment of the government. Says that if the elections are there, then steps will be then
For elections, like reporting the. Can the shareholders reporting. Like, my submission is there. I'm only on 42. Understood. That prescribed it to be okay, not 5 meeting. Now the presence is not, prescribed not presence in 5 meeting. That prescribed only 2 attendance in 5 meeting. Understood. So, out of which 3 meetings were not held. So, my lord, my submission is that, my lord. They attended, one person had attended in one meeting. One meeting. One. So therefore, 2 meetings over, phone number 6 is already out. He already attended 2 meetings. And because response number 7, he has attended 1 meeting. But if it was a phone on the part of the party or the cooperative society, not
No, my lord.
the meeting.
My lord, respondent number 6 also attended 1 meeting. Lordship kindly see paragraph, paragraph 11. If I am not wrong, 171.
Yeah.
Okay.
Bound to be held.
The respondent number 6 was not found to be present in the meeting held on 39 and so and so. 2 meetings. Not found to be present in the AGM dated 39, 2018 and
Now let us see the order.
read order, lords.
So we speak to it. So read the order.
Order, my lords. Annexer 1, lordship, page 20 from 21 was Annexer 2.
So what does it say?
Yes, said about, my lord, our application. Page 22, 21. Second paragraph. Then his findings in page 23. Page 23 finding. Considering the above fact,
Bound to exclude before the reporting of the involving the issue of the of specific
I think we got to another 50 of the.
What does he say about this?
Page 23. Consider
In the yeah, in his order, he does not mention anything about those 2.
he said mandatory.
No. He did not mention that he intended. Argues that no ATM of the air was going to.
He has not given any reason on that. But so far as our claim is that they are not attend, that is in present 120.
But what do you say about this page 45? Page 45. Abdul Bari.
Yes.
Abdul Bari in response number 6. He's there in this 17,
18. One meeting here there.
18, he's there.
He is there. One meeting here they attend. Both of them attended one meeting. According to affidavit filed by the respondent number 2 by the petitioner, who has passed the order.
And you attended
We attended my on phone.
all the meetings.
Against us, there is no
And
allegation.
you did not complain.
My lord, we are the shareholder. Some of
No, respondent number 1 and 3 are one of the,
we have contested and we have elected.
no, elected member, my lord. Respondent number 1 and 3 are the elected member.
Then
One
One
have challenged, my lord, the election of respondent number 6 and 7.
why? Why?
Lordship,
Why?
And my lord,
my lord, information of the body, if the person who are illegally elected enter into my lord vote, then the information of the vote, my lord. Then in that. And so far as the 1 and 3 is concerned, they are present in all the.
now they are member of the board, my lord.
We are member of it. You can challenge it.
And what about you?
Who is shareholder?
This complaint is filed, my lord, beyond the period of 3 days. Limitation period of 3 days. my lord.
You are fine.
Beyond the limitation period of 3 days. They filed complaint on 5/9/2023 and 12/9/2020.
5/9.
5/9/2023 and 12/9/2020.
When was the election results given?
Election 29/8/2023. The period of 3 days.
29/8/2023. And when was the complaint filed?
Complaint filed on 12/9/2023 and 5/9/2020.
There are two complaints.
By different parts,
Finally, similar to the complaints.
by different shareholder.
Now, did you file?
Yes, sir.
When did you?
My name is there, my lord, in hearing, my lord. In hearing, lord, page 20.
No. Did you file the election?
Yes, complaint filed.
It's an election petition.
Yes, my lord. We file election petition.
Because there is a difference between the complaint and the.
Yes, we have filed. them.
When did you file?
Yes, on 5/9/23 and 13/9.
5/9.
No.
On 5/9
Why are two different files? All have filed separate?
separate.
Okay, you filed when?
On
Register
5/9.
number 1
5/9/20.
on 5/9/2020.
No.
This is 7 days. Why? How could this be taken into consideration? Does he have the power to hear?
My lord, on that I say.
Huh?
Rule 27.
There's no power to
But
elect.
no power means, my lord, rule 27 says, my lord, any dispute relating to election of property may be submitted.
Within
Lord,
3
that not
days
true.
from the date
Today,
of the
my lord.
election, a month before the election occurs.
That
Means
is-
it can be submitted at any point of time.
My lord, it is the registered. On that ground, registered has not decided, my lord. Registered has not rejected on that ground. And my lord, this does not say the registered has no power to, my lord, consider.
Power has to be given.
No, my lord. May file means, my lord,
No, if the statute does not give the power,
yes,
means it is implied that there is no power.
yes. On that,
Oh, no, there's no question of.
my lord, lordship, I read again, ma'am. Any dispute relating to election of property society may be submitted,
Hmm.
submitted within 3 days from the date of declaration of the result before the election of the. My lord, it does not restrict to submit after the 3 days of. My submission.
No, the may has the effect of anybody. A discretion is given to any person. It is not on the version of limitation.
But it start with maybe submitted within maybe.
Yes,
submitted.
maybe. So maybe. So cannot be, has to be submitted.
Yes. Or should, if it is true, submit within 3 days, then it is mandatory in my. So my submission is that it is directory. That 3 days period is directory. Look, heard Mr. J.N.E. Chaudhary, the Learned Council, appearing on behalf of. Mr. D. Botwell appears on behalf of. 1, 5. So then appears for respondent number 6 and 7. The present petition has been filed by the petition. In what judgment? Challenging the order dated 3/11/2023. Insofar as it relates to the respond number 6 and 7. And further, six, for a writ in the nature of certiorari. To set aside and quash the election of the respond number 6 and 7 at the board of directors of the cooperative society. Next, the brief facts of the instant case depends on set. A society in the name and style of, a cooperative society in the name of style of Tengaguri Samavai Committee Limited, Morigaon. In the cooperative society registered under the provisions of the Assam Cooperative Societies Act 2007. An election was held to the board of directors of the said society. About the Tengaguri Committee, hereinafter referred to as short cooperative society. An election was held to the said cooperative society on 29/8/2023. Or were held on 27/8/2023. Whereby the petitioner number 1 and 3, along with the respondent number 6 and 7, have been elected as directors of the said cooperative society. Taking into account the issue involved, it is relevant to take note of the period prior to the elections held of the said cooperative society on 27/8/2023. The said cooperative society
No. The previous term of the said cooperative society was for the period. No. The said cooperative society was initially was no. The previous term of the said cooperative society term of the board of the previous cooperative society was with effect from 2016. Yeah? Any date? Any idea? Because in 2017, when they held it, it is almost 1 year. So from 2016 onwards, it has to be from 2016 onwards, not 17, 18. Not 17. It has to be from 16 onwards. If you are to count from 2017 is the first EGM. First EGM is to be held within 6 months from the end of the financial year. So it has to be that has to be taken for 2016-17. Understood. So therefore, when they held the first EGM 1 year before, so it has to be from 2016-17.
Yes, 5 years.
Previous 5 years has to be taken because if the first AGM was held, the first AGM is to be held when?
According to me, my note from 17, 18, 16, 17, 16, 17.
16, it has to go from 16-17.
17.
So therefore from 16-17, 17-18, 18-19, 19-20, 20-21.
And my note meeting was held in 23.
Maybe there must have been under 41-6, the executive officer must have been done it.
Yes, yes.
I'm not on that. But it has to be from 16-17. It cannot be from 17-18. Because the first AGM was held within 6 months from there. So therefore there was no problem with me. And on 16-17 did he participate? That is the most, if he has participated 16-17, okay, he can't. That cannot happen. Huh? The previous 5 years, the term of the board of the said cooperative society prior to the elections which were held on 27/8/2023 was with effect from 2016-17 to 2020-21. In terms with Section 31 of the Assam Cooperative Societies Act 2007, hereinafter referred to as the Act of 2007. It is an admitted case of both the parties that though it is the requirement of law in terms with Section 39 of the Act of 2007 that there has to be a general meeting, AGM, annual general meeting. At, le- at least one, a general meeting, at least once in every cooperative year within the period of 6 months of the close of the financial year. But the general meetings for the year 2017-18, 18-19, 19-20 were only held on 27-2017, 30-9-2018, and 19-9-2019 respectively. No, general meetings for the financial year 2016-17, 17-18, 18-19, 19-20, and 20-21. Ito 17-18, 16-17 were held on 27-2017, 30-9-2018, 19-9-2019 respectively. And there was no general meetings held for the financial year, cooperative years 19-20 and 20-21. The materials on record further show that the respondent number 6 and 7, out of these three financial cooperative, out of the three general meetings which were held, that is for the cooperative years 2016-17, 17-18, 18-19, they only attended in the meeting held for the financial year cooperative year 16-17, that is on 2027-2017. In the backdrop of the above, the issue therefore arises as to whether the respondent number 6 and 7 were disqualified in terms with section 40(2) of the Act of 2017, 2007, or 2007, to be chosen as directors in the election which was held on 27/8/2019, or 23. The records further reveal that pursuant to the declaration of the results of the directors on 29/8/2023, various complaint petitions were filed in the form of election petitions on 5/9/2023, 12/9/2023, and 30/9/2023, which have been enclosed as Annexure 1 to the petition. It may not be out of place to mention that the petitioners herein filed the application on 5/9, election petition on 5/9/2023. The election petitions so filed were disposed of, were dismissed, rejected, were disposed of by the impugned order dated 3/11/2023, whereby the nomination papers of respondent number 6 and 7 were upheld by the respondent number 2. On the ground that Section 40, the disqualification is mentioned in Section 40(2) of the Act of 2007 could not have been applied, taking into account that for 2 consecutive years, that is for cooperative, that is for 2019-20 and 2020-21, elections for general meetings were not called by the board of directors of the cooperative society. It is under such circumstances the present regulation. The records reveal that pursuant to the filing of the instant petition, the learned coordinate bench of this court, by an order dated 22/11/2023, issued notice and further observed that any actions taken by the new board of directors shall be subject to the outcome of the petition. The records were show the respondent number 6 and 7. You have filed affidavit. Respondent number 6 and 7 has filed an affidavit in opposition. Who affidavit? Huh? Who affidavit? Who affidavit in opposition? Why? No. There are some geographical mistakes are there, my lord, in the past. I've filed an affidavit in opposition on 8/2/2024 and an additional affidavit in opposition on 3/5/2024. The respondent number 2, who is the register of the cooperative society, has also filed an affidavit in opposition on 1/5/2024. Taking into account the impugned order, which was passed on 3/11/2023 by the respondent number 2. It is relevant to take note of the contents of the affidavit in opposition filed by the respondent number 2. From a perusal of the said affidavit in opposition filed by the respondent number 2, it was mentioned that the respondent number 6 was present in the AGMs held on 16/9/2016 and 27/2017. Whereas the respondent number 7 was present on 19/9/2019 and 16/9/2016. It was further mentioned that AGMs were not held for 2020-21 and 21-22 on account of the COVID pandemic. And as such, the disqualification under section 40(2) of the Act of 2007 could not have been applied. So therefore, 16/9/2016 is the first thing. When they did, huh? No. That was the AGM where elections were held. So therefore, the term started from the date of the election of the director. As per 31. So date of the election was on 16/9. So therefore, the date of election 16/9, that cannot be construed to be a period of 5 years. So he will go to 16/9/2016. But the meeting was held on in my first, second paragraph of the proposal, 16/9/2016. And here he's wrong then. 2020-21, it couldn't have been 21-20. Large. The respondent number 2 have stated various details as regards the participation of the respondent number 6 and 7 in respect to various meeting in the general meeting. But this aspect would not have been let me see. As regards the participation of the respondent number 6 and 7 in the general meetings. Inasmuch as it could be seen from a perusal of paragraph number 16 and 17 that it is averred by the respondent number 6 that the respondent averred by the respondent number 2 that the respondent number 6 and 7 had attended more than 2 AGMs in the previous 5 years, that is 2015-16 to 2018-19. At this stage, before further proceeding, this court finds it very pertinent to take note of that the perusal of the impugned order dated 3/11/2023, 3 or 13, 3, do not mention about the participation of the respondent number 6 and 7 in the annual general meetings, in the general meetings. Rather, the said order is based upon the non-necessity to comply with section 42 in a circumstance when AGMs were not held on account of the fault of the board of directors. Applying the law laid down by the Supreme Court in the case of Mohinder Singh Gill versus Election Commission of India, reported in so and so. The averments so made by the respondent number 2 as regards the participation of the respondent number 6 and 7 in the various meetings, therefore would have no relevance for deciding as to whether the legality as regards the as regards the legality of the order dated 3/11/2023. This court also takes note of that no affidavit in reply has been filed by the petitioners in the meantime. In the backdrop of the above, let this court consider the respective submissions on behalf of the parties. Okay? Over lunch, then I'll take the further. Yes, what is this? Who is there online?
My lords, I beg to mention for the item listed for at 2 p.m. This is writ appeal number 7. This is the dog meat matter which my lords has carried on from the bench at Kohima.
Yes.
My lords, we had moved an adjournment slip yesterday. The learned senior counsel Pinky Anand is on her legs in a part heard before the Supreme Court. If your lords could give a very short date, we can argue and we inform the other side. We can finish the arguments on 21st July subject to your lord's convenience.
How many matters we have on 21st July? Not so soon. We'll have it some other day. We'll do one
My
thing,
lords-
we'll again make your prayer at 2 o'clock. Because 2
At 2
o'clock
o'clock.
is session. It has been mentioned out there, so renew your prayer at 2 o'clock.
Oblige your lordship. We'll do the same. We'll do the same. Here on behalf of the appellates in writ appeal number 7. My lords, we had made a prayer for adjournment. A slip had been circulated yesterday and the other side had been informed by a local counsel. My lords, the senior counsel is on her legs in the Supreme Court. If your lord could give a short date, we'll be available to assist your lordship.
What do you say? Mr. Iralo? What do you say, Mr. Iralo?
As far as I'm concerned, I have no objection.
I want to hear on the next date as to whether this court can exercise the powers under 98 or the provisions of the latest patent without the points of difference being formulated by the two judges. Because if there is a difference of opinion of two judges, then isn't it required for the two judges to formulate the points of difference so that the matter can be referred to me?
Yes, I agree. Points of difference should have been formulated.
You get it, Mr. Kamrat?
My lords, we understand we'll be there to assist your lordship on this very point as well.
You assist me on that aspect because it is the point of difference where I have to decide.
Absolutely, my lords.
And there is a big problem out here in deciding the point of difference in view of one judge did not look into the provisions of Article 371A. And one judge looked into the provisions of the Article 371A. Because that is the issue on which one has to decide.
Absolutely, my lords. We understand the situation my lords are in
Because
without there
this
being
has
a
to go on the
reference.
position of the customs. That would be the case of Mr. Iralu, I suppose, isn't it? What do you say, Mr. Iralu? I can't hear you. Speak loud.
My submission is reflected in my pleadings as well in the written petition.
Put the mic above you.
Yes.
Yes,
Can you also hear me?
yes.
Yes. Now, in my pleadings, I stated that of course, I have made some arguments regarding the customs as far as the practice of consuming dog meat is concerned, I have narrated the history. Now, however, insofar as the question in the petition is concerned, my humble submission is that the petitioners, or in fact, the petitioners are aggrieved with the construction which has been placed by the director in the circular. Now, we are not aggrieved, we are not challenging the act or the regulation. We are saying that the regulation is correct. We're saying that the act is correct. And it applies to Nagaland also, because it pertains to food safety. But if we are to question, or if we are to examine regarding the Article 371A, then in my humble submission, that would assume that the construction which has been placed by the respondent in the circular is correct. If it is not correct, then 371A will not apply. Or in fact, the question of going into 371A may not arise. But if the construction which has been placed by the respondent in the circular is correct, then yes, that may involve dwelling into Article 371A.
So you are not relying on 371A?
As an alternative submission, I am making this, but not my primary submission.
Okay.
My lords, in fact, if I may just interject for a brief moment, my lords, the pleadings on respect to 371A were not raised before the learned single judge. It was only a query of the bench before the division bench, what 371A argued. In fact, it is the pleaded case of the respondents that they do not wish to raise issues of custom. It is a part of their pleadings in the writ petition. So, on that aspect as well, my lords, we have a fair few points to show your lordship that this is not a custom that is essential to the Naga tribe. It is also a case that the FSS Act is a Food Safety Act. It is not an act in respect of customs of Nagas. So, those are all questions of law that were taken up before the division bench. One judge of that division bench gave his finding. The other judge, despite hearing arguments, chose not to entertain that part or even give a reasoning. But that need not be seen as a decision on one side or the other. That is, in fact, a decision not to enter into that analysis because no pleadings to that effect were made. In fact, there is a admission that we don't wish to enter into that domain at all by the respondents. My learned senior will be available to assist your lordship on that question as well.
Heard Mr. So-and-so, the learned counsel, appearing on behalf of the appellant in Wikipedia. November 2023. He submits that the senior counsel unavailable pay on account of being busy in the he therefore seeks for an accommodation. This matter again on 23rd of July 2006 at 2 p.m.
23rd?
23rd.
23rd, now, of course.
My lords, I apologize. I'm sorry, but the date was not audible to me. If my lords may just repeat the date
23rd.
fixed. 23rd. My lords, 23rd is a difficult date. My lords, if 21st or 27th of July could be fixed, my lords.
Mr. Counsel, this court does not function at the whims of the senior counsels.
I recognize
Absolutely
that.
no.
My mistake, sir.
So therefore, either you get hold of a different senior counsel.
We'll be
He is
there,
not
your
available,
lordship, on the
or you
23rd.
argue by yourself.
We'll
Today
take care
I'm
of it, your
recording
lordship.
it for the first time. Don't expect it on the next stage.
Thank you. Obliged. Obliged.
Mr. J.V. Chaudhary, General Counsel, appearing on behalf of the petition. Petition submitted. that section 40 of the Act of 2007 stipulates the various criteria when a shareholder would be eligible to become a director of the cooperative society. He further submitted that a perusal of section 40 bracket 2 of the Act of 2007 mandate that for a shareholder to be elected as a director, the shareholder has to attend at least 2 annual general meetings in the previous 5 years. And in the instant case, as the respondent number 6 and 7 have only attended 1 general meeting in the last 5 years of the term of the board, the respondent number 6 and 7 would not have contested the election for being eligible election to the directorship of the property of the board of the cooperative society. The learned counsel further, referring to the impugned order dated 3/11/2023, submitted that this aspect was not taken into consideration in the proper perspective. The learned counsel further, referring to section 130, capital A of the Act of 2007, further submitted that the exemption which is being can be granted by the state only is in respect to section 39 and section 41 bracket 2 of the Act of 2007. And there is no exemption even which can be granted by the state, thereby entitling a shareholder who had not participated in the meeting, in 2 annual general meetings, to contest the elections. That's it. Yes. By contrast, Mr. D. Bodlow, the learned standing counsel of the corporation department, submitted that in the instant case, the cooperative society in question did not hold 2 general meetings. Though they were required to hold 5 during the term of the board. He therefore submitted that there was no illegality committed by the respondent number 2 in exempting the petitioner, the respondent number 6 and 7, from the clutches of 40 of section 40 bracket 2 of the Act of 2007. In as much as the shareholders cannot be blamed for not holding the AGM by the board of directors of the corporation. Mr. So-and-so, the learned counsel. Mr. So-and-so, the learned counsel, appearing on behalf of the respondent number 6 and 7, submitted that the respondent number 6 was present in the meetings which were held on 27, 2017, isn't it? And respondent number 7 was with respondent number 7 was present in the meetings held on 27, 2017 and 19/9/2019 and 19/9/2019. As would be apparent from the minutes of the meeting, it will be apparent from the share, the attendance register of the meetings held on 27, 2017 and 19/9/2019. He further submitted that as regards the respondent number 6, he had attended the meeting which was held on 27, 2017 and 16/9/2016. Isn't it? Yes. The learned counsel further submitted that section 40(2) of the Act of 2007 would only come into operation if a shareholder had not attended at least 2 annual general meetings in the previous 5 years. He therefore submitted that there is a requirement of holding of the annual general meetings. And there is no reference in section 40(2) of the Act of 2007 that the annual general meetings has to be specific to a particular term of the board. He therefore submitted that there is no quarrel with the fact that the respondent number 6 and 7 had participated in the meeting held on 16/9/2016 and on 27, 2017. And therefore, as amongst the last 5 annual general meetings, the respondent number 6 and 7 had duly participated. The said respondents cannot be said to be disqualified in terms with section 40(2) of the Act of 2007. Okay. That's it. Regarding section 27, they have filed complaint petition before the register member. Petitioner number 1 and 3, they are elected member. They have filed petition beyond 3 days without any verification or affidavit member. And this complaint petition, they filed after 3 days of the date of declaration of the result, which is violation of section 27 and division bench judgment. Input in Resi Thomas case, it is held that this limitation cannot be In addition to that, the learned counsel appearing on behalf of the respondent number 6 and 7 submitted that the petitioner's hearing the instant repetition is not maintainable. In as much as the petitioner have challenged the election of the respondent number 6 and 7 beyond the period of 3 days as mandated in Rule 27 of the Assam Cooperative Society Election Rules 2019. And therefore, the said challenge to the election of the respondent number 6 and 7 was beyond the powers was without jurisdiction, and therefore, as Rule 67 of the rules of 2019 do not empower the register to condone the delay. The very challenge or the order passed therein is also without jurisdiction. Mr. J. Chaudhary, the learned counsel, rejoining to his submissions, submitted that a perusal of Rule 27 of the rules of 2019 could show that that the word may have been used by the rulemaking authority, thereby meaning that filing of the application under section 20, Rule 27 within the period of 3 days is discretionary and not mandatory. That part also not discussed in the order 27 level regarding 47. Register, they have not read the name. That is not discussed. The learned counsel further submitted that the issue as to whether the respondent number 2 had the jurisdiction to condone the delay or even entertain the complaint application was never objected to by the respondent number 6 and 7 before the respondent number 2. Analysis and the issue involved in the instant proceeding. When it involves, it relates to the interpretation of section 14 bracket 2 of the Act of 2007. Under such circumstances, section 40 bracket 2 being relevant is reproduced hereunder. Perusal of the above quoted vision to show that a member of a cooperative society shall be eligible for being chosen as a director of a cooperative society if amongst others has attended at least 2 annual general meetings in the previous 5 years. This court finds it very relevant to take note of. Section 31 of the Act of 2007, which stipulates that the term of the board shall be 5 cooperative years from the date of election of the director. Section 2H defines the term cooperative year to mean the period beginning and ending on such date as may be fixed by the register for the purpose of drawing up the balance sheets of the registered society and for all other purposes under the Act of 2007. It is relevant to take note of that though the term of the board have been stipulated in section 31 as 5 cooperative years from the date of election of the directors, but a perusal of section 40 bracket 2 do not refer to the cooperative years. It specifically refers to 2 annual general meetings in the previous 5 years. Under such circumstances, it is the opinion of this court that section 40 bracket 2 of the Act of 2007 cannot be specifically limited to the term of the board in question, which is specifically mentioned in section 31 of the Act of 2007. This court further finds it relevant to take note of section 39 of the Act of 2007. The said provision being relevant, it reproduced hereunder. From a perusal of the above quoted provision, it would be seen that it is the duty of the board of directors to hold at least once in every cooperative year within a period of 6 months of the close of the financial year to transact the businesses provided in the Act of 2007. In other words, it is the requirement of the board of directors to hold one general meeting once in every cooperative year within a period of 6 months of the close of the financial year to transact the business of the Act of 2017 as provided in the Act of 2017. It is further stipulated in section 39 that by operation of law, the board shall automatically self-dissolve for not holding the annual general meeting in accordance with the provisions of the Act of 2007 and the bylaws within 6 months of the expiry of every financial year. It is to be noted that the financial year is to be counted from 1st of April to 31st of March. In the instant case, the period in the instant case, as the board in question was constituted pursuant to the elections which was held on 16/9/2016. The general meetings were to be held on or before 30/9/2000. And 5 general meetings were required to be held on or before 5 general meetings for the cooperative years were to be held as tabulated herein under 2016-17 on or before on or before 30/9/2017, 17/18 on or before 30/9/2018, 18/19 on or before 30/9/2019, 19/20 on or before, that will change. 19/20 would be on or before 31st of March. 31st of March 2021. And 2021 on or before 31st of March 2022. 31st. It is seen that there was no general meeting held for the cooperative year 2019-20. And it was therefore, by the operation of law, the board of directors of the cooperative society ought to have been dissolved. However, strangely enough, the board of directors of the cooperative society were allowed to continue. And it was only dissolved on no, it was dissolved prior to that. 20, that date is not. It was dissolved much later. Upon orders being passed by the officers of the corporation department. However, by operation of law, the term of the board dissolved as on 31/3/2021. In the backdrop of the above, if this court now takes note of section 40(2), it would be seen that insofar as the attendance of the general meeting is concerned, the last 5 years ought to have been taken with effect prior to 31/3/2021. And If that period is being taken, it would also show that the respondent number 6 and 7 were present on 16/9/2016 and 27/27/2017. And therefore, they could not have been disqualified to be chosen as shareholder directors by virtue of section 40 bracket 2 of the Act of 2007. This court further takes note of the above issue. Therefore, in view of the above, it is therefore the opinion of this court that the elections to the respondent number 6 and 7 cannot be disturbed on the basis that they were disqualified in terms with section 40 bracket 2 of the Act of 2007. This court, now in view of the above opinion, this court is not entering into the arena as regards whether filing of the election petition within the period of 3 days is mandatory or directory. And this aspect would be decided if so need be in a separate proceedings, as and when it arises. The question is kept open. With the above observations and directions, this court does not find merit in the instant writ petition for which the writ petition stands dismissed. I'm on this. Mr. Counsel, so far, why haven't you made the National Highway Authority a party? Your petition is very. Isn't it? The higher authority than the National Highway Authority. You do one thing, you withdraw. I give you the liberty to approach them. Better off. Because I can't pass a direction. Yes. Two wives. Huh? There are two wives. 2 wives, 3 wives, whatever may be. You have any claim, you go and heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 2 and 3. None appears on behalf of the Revenue Department on call. The present petition has been filed by the petitioner being aggrieved by the actions on the part of the respondent authority, more particularly the respondent number 3, for determining the compensation as payable only to the respondent number 4. Although the respondent number 4 is the second wife of late Daya Sankar Jeswas. This court duly takes note of that the present provision that the acquisition in the instant case is an acquisition carried out under the National Highways Act 1956. And in case of any dispute as regards entitlement or apportionment, it is the petitioner ought to have approached the concerned court in terms with section 3H bracket 4 of the National Highways Act 1956. The learned counsel appearing on behalf of the petitioner submits that taking into account the provisions of section 3H bracket 4 of the National Highways Act 1956, the petitioner would not like to further pursue with the instant proceeding, but without prejudice to avail remedies under section 3H4 of the National Highways Act 1956. Taking into account the above, the instant petition stands closed on withdrawal. Before parting with the record, this court observes that the withdrawal of the instant petition shall not preclude or prejudice the petitioner to avail remedy under section 3H4 of the National Highways Act 1956 before the which court? Gulaghat. Before the district judge, Gulaghat. If so advised. So and so appears for the revenue. Much obliged. Bata. Yes.
Both party has agreed for settlement of entire rupees of 6 lakhs. And we have submitted in the affidavit by both the parties. Agreed. But they took 15 days time.
No, my lord. My lord, we have filed affidavit saying that we have finalized the amount at 6 lakhs as one-time settlement. My lord, our affidavit we have submitted, they have also submitted, saying that, my lord, the matter will be accordingly closed and we will be paying, my lord, the amount agreed upon within 15 days from the date of acceptance of our affidavit by both the parties, my lord. That is the statement in the affidavit.
No. From the date of recording of this affidavit.
Yes, sir.
That is what. You pay within 15 days.
Yes, sir. And matter may, my lord, I pray accordingly closed. Matter may only be closed on the strength of the
Raise your affidavit.
on 15th of June we filed.
139 page number.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent.
Number one.
Number one. The present writ petition has been filed assailing the award dated 16/11/2015 passed by the learned presiding officer, Labor Court, in reference case number 4/2013, whereby the termination of the petitioner of the respondent number one was set aside and was held to be illegal, and directions were issued for reinstatement of the respondent number one with full back wages with effect from 16/11/2015. Next. It is clear from the materials on record that the petitioner have already been, the respondent number one has already been reinstated?
No, my lord.
No,
Okay.
they
Not
have challenged.
released.
They have challenged before it arrived.
This order, my lord, we have challenged. And in the meantime, they have a claim of 17 P.
Pursuant to the filing of the instant writ petition, the writ petition. The filing of the instant petition. it was brought to the notice of this court that the petitioner as well as the respondent number one have amicably settled their disputes. This aspect was brought to the notice of this court by the order in the proceedings held on 14/5/2026. And therefore, this court directed the parties either to file a joint affidavit or respective affidavits to bring to the notice of this court about the settlement. In pursuance thereto, the petitioner had filed an affidavit on what is the date?
15/6/2020.
Huh?
15/6,
On 16/6. On 16/6/2026. Wherein the petitioner had undertaken to make payment of one-time, wherein the petitioner undertook to make payment of the one-time settlement amount of rupees 6 lakhs in favor of the respondent number one within a period of 15 days from the date of acceptance of the respective affidavits of the parties before this court. This court also takes note of another affidavit filed by the petitioner, respondent number one, on 16/6/2026, wherein the respondent number one had agreed for a one-time settlement of the pay matter or rupees 6 lakhs for his claims from management of Bata India Limited, that is the petitioner in the instant petition. It is also categorically mentioned in the said affidavit by the respondent number one that upon receipt of the amount of rupees 6 lakhs, the respondent number one shall have no further claim against the petitioner company in respect of his claim in reference case number 4/2013 in future. Taking into account that both the parties have amicably resolved the dispute as have been duly mentioned in their respective affidavits. And it is the further opinion of this court upon perusal of the materials on record that the said amicable resolution of the dispute is without any fraud or any coercion and undue influence. This court accepts the amicable resolution. Accordingly, this court disposes of the instant proceedings with the following directions. The petitioner herein is directed where? Account?
They have already shared with us.
Huh?
They have already shared the account details with us.
It has been informed, number one. It has been duly informed that the petitioner have already provided the bank details to the respondent number one has already provided the bank details to the petitioner.
To the counsel for the petitioner, to me, they have provided. already. Yes, my lord, yes.
To the petitioner. To the petition. Under such circumstances, the petitioner is directed to transfer the amount of rupees 6 lakhs to the bank account of the petitioner within a period of 15 days from today. Number two. Upon transfer of the said amount of rupees 6 lakhs to the bank account of the petitioner, of the respondent number one, by the petitioner, all claims, all rights, claims in respect to the award dated so and so passed in reference case number so and so shall automatically stands shall automatically stands satisfied. Number 3. This court grants liberty to the respondent number 1 to file an application before the registry in the circumstance within 15 days from today the amount is not transferred to the account of the petitioner, and the registry thereupon is directed to place the matter before this court. With the above, there shall be no orders post.
Deeply obliged.
Maybe. My lord, kindly see the order dated 25/2/2026. We have lost it.
25?
25/2/2026. In this
A.
order, my lord, I
Hussain
can
so-and-so,
respond
President
in
has been
written.
filed seeking compensation on account of statutorily committed by the state as well as the direction he has should. That the respondent number 3 and 4 should allot a plot of land to the petitioner, taking into account that the petitioner admittedly was residing over the land for the last 40 years. That regard the petitioner has submitted a representation on the same amount. It is by the order the part of the permit to reside over on certain terms of the state part of the government by. But so the document to take note of the terms and conditions which are issued. Issued by the. After this affidavit is filed,
No, my lord, yes, affidavit filed, but my lord, there is no, my lord, notice, no verification report has been, my lord, furnished, my lord, as per direction of this honorable court, my lord. My lord, kindly see page 94, my lord, joint verification report, my lord.
page 92.
Page 94. The manner of joint verification report, my lord. And there is no notice, my lord, as on that, they can place, my lord, on record, my lord.
reserve forest name is Nolbari, but it is in Gwalpara.
Walpara. Look, it's mostly it says that
Lokhipur Revenue Circle.
Revenue Circle, Lokhipur Revenue Circle,
But it is in Gwalpara.
Golpara. And as far as he's stating that there's no notice was issued, your lordship, a general notice was issued. because as Lordship Abdul Khalik came on later on, where individual notice was supposed to be served to the encroachers. This eviction
But
happened,
how did you delineate your boundaries?
Lordship.
Where's your boundaries?
The verification report, Lordship, verification is
Verification does it so. Where's your boundary? There's no boundary. Where's your notification? The moment you are saying to be a public reserve forest, you have to bring the notification.
Yes, sir.
You cannot say one fine day, okay, this is the notification. You delineate your boundary.
Notification has to be there, Lord.
Supreme Court may have stated out there in Abdul Khalik, now this is going to be followed.
Yes, yes.
The Supreme Court interfered with the action on the part of the revenue authority, the police authority, the forest officials to throw somebody out without notice. And therefore have laid down these principles.
Yes.
Now, when the judgment has come in, the judgment does not say prospectively this will happen only. So when the law is being declared by any court, unless it has been said to be prospective operation, it will always have a retrospective operation. That is one. Anyways, the fact remains that it has to be a reserve forest.
There has to be a notification.
And to be a reserve forest, there has to be a notification.
Exactly.
One. Where is the delineation of a boundary? That how did you find out that he is in these geographical coordinates? Did you make out, find out, or did you make any scientific analysis of, or did you, as regards the boundaries out there, did you find out which are the boundaries?
That aspect is not clear.
You see, the joint verification report which has been enclosed out here to the affidavit filed by the respondent number 4, kindly see page 94, says about the GPS coordinates of the area and the encroachment are these.
Yes.
Now, have you scientifically formulated the boundary?
That aspect has to be clear.
If you have not done so, then what is this area? A person who has resided out there for 40 years have some rights. At least a notice. At least a hearing. Abdul Khalik says that, you see, the forest authority as on by themselves cannot evict without the presence of the revenue authorities.
Yes.
Therefore, the committee has been formulated. Forget about the committee now. The committee, okay, this is separately happening now. But what about the earlier period? He had some rights. He has been illegally residing, but don't you think that he had something to say on that? That is now, if it is a reserve forest, he can't be there.
Yes.
That is one aspect. But this is not satisfactory.
It's not satisfactory because it's only the GPS coordinates are done, and how the GPS coordinates were taken.
How?
are
How
they
can you
taken?
say that these are within the GPS coordinates? Is this we find out? No, it has to be scientifically analyzed
Just like we did in earlier.
with the river motor of this aspect. No, not properly done.
So, Ashok, this GPS coordinates have to verify. Let me clarify with this how this GPS coordinates were done.
Yes,
That's-
these are the
These are
GPS coordinates.
how
How
they
it is
obtained the GPS
there.
coordinates.
It is very sad. This order was passed by me on 2000, recently on 25/2. Okay. Yeah.
25/2, my lord, 25/2.
I think this matter needs to be tagged with me. Then only things will.
Yes.
Second aspect is, why was his application for allotment rejected?
Yes, my lord.
Found in the Punjab forest area.
Huh? Why? What? Paragraph 5 is disastrous. Very difficult to appreciate these type of contentions. The deponent respectfully states that the petitioner occupied the forest land and the applicant, a person from general category, and an encroacher's application for allotment of encroached lands could not be accepted. My goodness.
My lord, I have been allotted in the year 1983, my lord,
Then
by the deputy commissioner itself, my lord. And my lord, as for land policy 19, my lord, they ought to have been, my lord, settle the land in my favor, my lord.
has your land policy changed? Then, and if he was there in the reserve forest, one thing is very clear. He set up his building, the authority of somebody inside the reserve forest, let it be. Prior to 1980,
1983,
1983, my lord, it was, my lord, that allotment was given to the father's lord.
father,
Yes.
around 83.
83, and the, my lord, that
1983.
notice is clearly stated. Lordship, may kindly see his petition, Lordship.
Where?
Lordship, page 23, the vernacular. Lordship, paragraph number 4. The আবণ্টন হোৱা মাটি আন কোনো লোকক উত্তৰাধিকাৰী হোৱা ৱাৰিছ সূত্ৰে উপায়ুক্ত মহোদয়ৰ বিনা হুকুমে দখল ভোগ কৰিব নোৱাৰিব।
Then,
But it was given only 1983, Lord. 11/4/1983.
read it properly. Number 4.
Number 4.
What does it say?
আবণ্টন হোৱা মাটি আবণ্টন পোৱা মাটি আন কোনো লোকে উত্তৰাধিকাৰী বা ৱাৰিছ সূত্ৰে উপায়ুক্ত বা মহকুমাধিপতি বিনা হুকুমতে দখল ভোগ কৰিব নোৱাৰে। আবণ্টন পোৱা মাটি খেতিৰ উপযোগী কৰিবলৈ তাত থকা হাবি বন আদি চাফা কৰি থাকিব কিন্তু কোনো
মূল্যবান
গছ আদি উপায়ুক্ত বা মহকুমাধিপতি বিনা হুকুমতে মাটি বা অন্য প্ৰকাৰৰ হস্তান্তৰ কৰিব নোৱাৰি।
Then number 6.
Number 6, এই এলেকাৰ কৃষি পাম নিগম গঠন হলে আপুনি উক্ত নিগমৰ সভ্য হ'ব লাগিব। নিগমৰ সভ্য হলে আবণ্টন পোৱা মাটি দখল
নিয়মাৱলী মতে নিয়মাৱলী মতে
মাটি
সাল সলনি হ'ব পাৰে। আপুনি এই মাটিৰ আবণ্টন পোৱা আৰু তাৰ বাবে আৰ্থিক সাহায্য পোৱাত অযোগ্য বুলি প্ৰমাণিত হলে এই আবণ্টন পোৱা মাটিৰ দখল এৰি দিব লাগিব আৰু আৰ্থিক সাহায্য হিচাপে পোৱা সমুদায় ধন ঘূৰাই দিব লাগিব। এই প্ৰমাণ পত্ৰ ভূমি আৰু ৰাজহ আসাম ল্যান্ড এন্ড রেভিনিউ রেগুলেশন এক্ট 1986 উল্লেখত একশনা মেদি বা আন কোনো No, no.
The land was given to whom? Mofused did.
My lord, yes, my father, my lord, in favor of my father, my lord. My father died thereafter, my lord.
Your name is Santosh Ali.
Yes, my name is Santosh Ali.
Now, if his name has been recorded
Yes, my lord.
in the record of rights, in the Chita for the surveyed village,
Yes. And accordingly, my lord, I have been paying my lord revenue, land revenue also, my lord. Is paying the my lord at up to 2021.
huh?
So this,
No, it's okay. His name has been duly recorded.
lord,
So it means that it has the permission or the blessings of the Deputy Commissioner.
I was evicted, my lord, on 17/7/2023, my lord.
And read this paragraph, page 28.
Please.
Does this the document show that it is Tozi Moza? You see, you have to reconsider his application first. We keep the matter pending. Reconsider his application. The reason given in paragraph number 5 is absolutely. We cannot accept. You reconsider his application as per law, whether he is entitled as per the Assam land policy. We have it after 60 days. In the meantime, you file your proper affidavit. In the meantime, if you can give it to him the land, give him. Not that. He filed in 2020, 11-12. 11-12.
Minus
Then
11.
reconsider his application. And you filed a complaint case.
Lordship, yes, my lord, I also filed complaint case.
What has happened?
My lord, my lord, I have no instruction to that effect, my lord.
Huh?
What is going on, my lord, that I have not.
Lehok. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. R.R. Gogoi appears on behalf of the Forest Department. Mr. for the Revenue Department, and Mr. J. Hendig appears for the District Administration. Pursuant to the order dated 25/2/2026, an affidavit has been filed by the circle officer.
Respond number 4, Lord.
Lokhipur Revenue Circle. First. In the said, to the said affidavit filed by the respondent number 4, a joint verification report on Nalbari RF dated 28/6/2023 have been enclosed. It surprises this court to take note of the contents of the said joint verification report, inasmuch as it is being it was made at the behest of certain officials from the Lokhipur Revenue Circle and the Forest Department officials. The joint verification report do not mention as to who is the officer of the Forest Department and what is his designation.
Yes.
It further surprises this court that a joint verification report pertaining to eviction to be carried out is being done at the behest of the lot mondal and without the participation of the circle officer. This court also takes note of the joint verification report wherein there is a mention of certain GAPS coordinates. However, there is no mention in any of the materials on record to show as to how these GPS coordinates have been found to be a part of the Nalbai Reserve Forest. There is nothing on record to show that there has been any scientific basis, nothing on record to show that scientifically the boundaries of the reserve forest in Cochin have been reduced into longitudes and latitudes. Merely on the basis of orders being passed. This court also have taken note of the stand so taken by the Divisional Forest Officer Gwalpara Division in the affidavit filed on 3rd of September 2025, wherein also wherein it is seen that the respondent in the forest department have taken the stand that such actions have been taken on the basis of orders being passed by the learned division bench in the PIL Sumoto number 1/2022. This court finds it very pertinent to observe that the order dated perusal of the order dated 5/9/2022 does not grant the forest officials to evict any person without following the due process. This court further, by the order dated 25/2/2026, had directed the circle of the Revenue Department of the Government of Assam to apprise this court, the respondent number 3 to apprise this court as to why the petitioner's application seeking allotment was rejected. And it surprises this court from the contents of paragraph number 5 of the affidavit filed by the respondent number 4, wherein it is mentioned that as the petitioner occupied the forest land and the petitioner was a person from general category and an encroacher's application for allotment of encroached land could not be accepted. This, in the opinion of this court, the reasons were signed in the said affidavit is completely contrary to the Assam land policy of 2019, as well as the Assam forest policy of 2004. Under such circumstances, the very rejection of the petitioner's application for allotment is required to be interfered with. In that view of the matter, this court therefore interferes with the rejection of the petitioner's application for allotment and the respondent authorities, more particularly the Revenue Department as well as the District Administration of Goalpara is directed to reconsider the application of the petitioner for allotment in any other revenue lands during the pendency and forthwith and provide an update before this court on the next date. First, insofar as the affidavit so filed by the respondent number 5, this court directs the respondent number 5 to provide details of the notification of the Nalbari Reserve Forest and further as to whether scientifically the various boundaries of the Nalbari Reserve Forest have been identified with longitudes and latitudes, and if so, when an affidavit in that regard be filed by the respondent number 5. First, list this matter again on 17th of September 2026 for an update. Matter may be shown as part of. Let me come back.
My Lord, while preparing for the reply argument, my Lord, I have come across a case of the, not one, my Lord, 2-3 cases of the Supreme Court, which has got a vital bearing in the adjudication of this case. One point, my Lord, I have pleaded. One point I have not pleaded. Because it's a new aspect which was made known to me. This is something like this, my Lord. Supreme Court has said that when it comes to making any appointment, ideally there should be a rule, 309 rules. Supposing there are no rules, even then appointments can be made. But there, if it is state government, they can invoke 162. If it is union government, it can invoke Article 73. Now, my Lord, how interview will be held? What would be the component of marks of the interview? What would be the component of the marks of written test? These are ideally, it should be laid down in the rules. And all these procedures should be, my Lord, mentioned in the advertisement. Now, in this case, my Lord, Rule 19.2 does not say all these things. Now, therefore, my Lord, Supreme Court says, selection committee has no authority to devise any such procedure. I can place that judgment, my Lord. That's why I felt, my Lord, I must inform your lordships. There are two, become a copy to be fair to the state, my Lord, this one point I have not pleaded, my Lord. First, my lord, will have this 95 case, my lord.
Yes.
My lord will kindly come to para 28. Coming now to the merits of the selection, we may at the outset indicate that the decision of the selection committee can be interfered with only on the limited ground, namely there was an illegality or material irregularity in the constitution of the committee or in its procedure vitiating the selection or prove malafide, etc., etc. Let us therefore examine whether selection in the instant case is vitiated by any of these factors, as also by the basis, mode and procedure allegedly arbitrarily adopted by the selection board in adjudging the suitability of the medical officer for their appointment on technique teaching posts. The tribunal has quoted the minutes of the proceedings of the selection board in a judgment dated 14/5/90, and it will be useful to reproduce the proceedings here as well. The board decided that selection to the post of demonstrator should be made from amongst eligible homeopathic medical officer, strictly according to the merit and suitability with due regard to the seniority. The chairman pointed out that since the recruitment rules do not provide specific principle and guideline to judge the merit and suitability of the candidates, same should be judged basing from the CCR, that is confidential character rules of the candidate. This is because they have the requisite qualification and prescribed 1 year service to their credit. Their performance and suitability is reflected in their CCR from year to year. To this contention, Dr. K.K. Kaur, principal cum superintendent, objected by saying, inter alia, CCR may be one of the consideration but cannot be the sole consideration for selection as demonstrator. He further said that for teaching job, academic knowledge and achievement and eloquence on the subject is very much required, for which interview needs to be conducted. Chairman and the other members of the selection board, differing from the contention of Dr. Kaur, opined that interview for a short time cannot be helpful to assess correctly the suitability of the candidate so far as knowledge and eloquence are concerned. Therefore, after discussion on Dr. Kaur's objection, the chairman and other members opined that when CCR of a candidate, the homeopathic medical officers are available, interview for a short while will not be sufficient to judge their suitability. Therefore, it is decided that it is not necessary to assess the academic knowledge and eloquence by conducting a personal interview. CCR will be the sole judge, sole guide to judge the merit cum suitability with due regard to seniority. The proceedings indicate that since Rule 3 was silent as to the guidelines on the basis of which suitability of the candidate was to be judged, the members constituting the selection board by a majority decision resolved to determine the suitability on the basis of confidential character role of the candidate were already employed as homeopathic medical officers. Now, power to make rules regulate, this is important, my lord, rules regulating the condition of service of person appointed on government post is available to the governor of the state under proviso to Article 309, and it was in exercise of this power that present rules were made. If the statutory rule in a given case have not made either by parliament or state legislature, or that had not been as a matter by the governor of the state, it would be open to the appropriate government, central government under Article 73 and state government under 162 to issue executive instruction. However, if rules have been made but they are silent on any subject or point in issue, the omission can be supplied and rules can be supplemented by executive instruction. In the instant case, government did neither issue any administrative instruction nor did it supply omission with regard to criteria on the basis of which suitability of the candidate was to be determined. The members of the selection board of their own decided to adopt confidential character role of the candidates who were already employed as homeopathic medical officer as the basis for determining their suitability. The members of the selection board, or for that matter any other selection committee, do not have the jurisdiction to lay down the criteria for selection unless they're so authorized specifically in that regard by the rules under Article 309. It is
There,
basically,
Mr. Chaudhary, there the problem arises. You see page 139.
yes, rule 19.2, Miller.
Accordingly, the selection board may devise appropriate method.
Exactly. No, I'm coming to it, Miller. Now, please permit me to read this, complete this, then I'll make that. I've seen that. Now, Millard will kindly come to para 33. The member of the selection board, or for that matter, any other selection committee, do not have jurisdiction to lay down the criteria for selection unless they are authorized specifically in that regard by the rules made under 309. It is basically the function of the rule-making authority to provide the basis for selection, court of state in so and so. Then Millard will kindly come to para 34. This selection committee does not even have the inherent jurisdiction to lay down norms for selection, nor can such power be assumed by necessary implication. By necessary, and then next para. Similarly, in Umesh Chandra Shukla, it was observed that selection committee does not possess any inherent power to lay down its own standard in addition to what is prescribed under the rules. Both these decisions were followed in Durgacharan Mishra, and the limitation of the selection committee were pointed out. It had no jurisdiction to prescribe minimum marks which a candidate had to secure at the viva voce. It may be pointed out that the rule-making function under 309 is legislative and not executive as laid down by the court in B.S. Yadav. For this reason also, selection committee or the selection board cannot be held to have jurisdiction to lay down any standard or basis for selection, as it would amount to legislating a rule of selection. Now, my lord, this is now, please come to the other decision, my lord. I'll just refer to one paragraph. Assuming, my lord, taking last sentence of 19.2 as the enabling provision, then also this selection vitiates on account of this. Para 27.1 at para 444. That the selection committee proceeded to fix the criteria for assigning mark to the candidate on the date of conducting interviews. The said criteria was neither revealed in the advertisement nor disclosed to the candidate prior to or even at the time of conducting interview. So this is a fatal ground below. The criteria was fixed on 13.8. It was never made public. Whatever criteria you adopt, you must specify in the advertisement.
No, it doesn't say.
Yes, so yes, my
No,
lord.
the
Kindly
same
see,
criteria was
neither revealed in the advertisement nor disclosed to the candidate. Where was it? Yes, prior to yes, it was never done.
The criteria was given as to.
No, it was
what are
not
the
given.
basis
For
on
the
which-
first time, they have enclosed in the affidavit. In the reply, we dealt with it. In the affidavit in opposition, they came up with it.
Regarding?
This criteria, my lord, that regarding that minutes of the selection board, that they are going to adopt this procedure.
No, they say in the affidavit that these were very well mentioned out there categorically in the, what are the things, what are the documents which are to be given at serial number 5 and 6 of those documents.
No, my lord, we have explained that in our affidavit. It was not done. I'll give the dates, my lord. No, I thought since this is no, my lord, there are that 19.2, my lord, I can appreciate, my lord.
I think 19.2, you
No,
need to challenge it there.
19.2 covers only one aspect, my lord. The last sentence. It covers the aspect of laying down, my lord, some guideline. But, my lord, that basic structure has to be laid down by the rule-making authority. Now, my lord, what would be the component of mark, etc.? My lord, the single judge, which was upheld, has dealt with all these aspects in this case of the Supreme Court. So, therefore, I was thinking, my lord, one, I would like to file one additional affidavit because this point I have not pleaded, my lord. Other point regarding advertisement, regarding the decision of the selection board that it was not made known to the, that point we have covered. But, my lord, this point we have not covered, my lord. So tomorrow this question might crop up that you have not even pleaded. So I just pray for a very short accommodation. I'll just file a small additional affidavit. I could have filed it, my lord, since I didn't have the permission. That's why I did not file it. This was, my lord, page 168. I'll just show, my lord. It would, na? If your lordship would kindly come to page number 168. For the first time, kindly mark the dates, my lord. 2/1/24 was the date of advertisement. 13/8/24, the LS decision, my lord. Then, my lord, 21/10/24 was fixed for Viva Bose. It was never disclosed, my lord. It was not part of the advertisement. That point we have
There's
taken.
no quarrel with that.
Yes.
It is not a part of that. The device, how it would be devised out there, it was not a part of it. There's no quarrel with that. But the fact remains that what are the bases are to be given, that 100 marks will be there, out which 70 marks for assessing the requisite quality, drafting skills, analytical presentation, skills, management, and all these things. 20 marks for assessing the requisite qualities, personality, temperament, and 10 marks for so and so.
Nothing will, I can show the call letter. There is nothing. My lord, I have a serious doubt, my lord. The selection which was made by the committee, that has never been acted upon. Something else has been acted upon. My lord, one of our colleague, Chandana Sharma, she appeared, my lord. Out of sheer anxiety, my lord, she checked, my lord. Her name does not appear, whereas her police verification was done. I also want to bring on record that aspect also.
What has happened?
My lord, she appeared, everything was done, her police verification was also done. It was done in two places because her in-laws' place are in Palasbari and her mother's place in Lopasi. In both places, my lord, police had gone, police verification was done.
Police
Whereas
verification is done when?
on the eve of appointment at 25. Now, my lord, her name does not appear among the person who appeared in the interview. How is it possible, my lord? My lord, I have a serious doubt, my lord. The selection which was done by the committee may not have been acted upon. Some other select list has been acted upon. If the records are produced, it might be revealed.
No records, they have already brought on record those things by way of an affidavit.
No, my lord, those records have not been. Whether the selection committee minutes have been given.
Yes, I have all the records, the mark sheets of the vote and attendance sheet of the candidates, everything I have. The photocopies I have, if necessary, I can produce the original. I have the entire record.
Let's see the records.
তোমার নাম তোমার দিশা পরিমাণ দিলা যাক যাক মাতিছে তার নামবিলাক আছে না সাপোজ মই এপিয়াৰ কৰিছো পুলিচ ভেৰিফিকেশ্যন কিন্তু তেওঁতো তাৰ লিষ্ট এখন থাকিব নহয়
You appeared before whom?
কোনখন কমিটিত এপিয়াৰ কৰিছিলে ইণ্টাৰভিউত জাজ ইট ওয়াজ লেড বাই জাজ
Huh? You appeared before whom?
জাজ কোন আছিল ইট ওয়াজ হেডেড বাই পার্টিকুলার জাজ
Name the High Court judge before whom you have appeared. Huh? There were 3 High Court judges. 3 High Court judges formed 3 SIF.
অনিমা বাইদেউ
What?
I think অনিমা বাইদেউ হাজারিকা
Just one thing. Let me have a look.
The serial numbers are logical find at the top left corner.
Just 1 minute. Let me just find out one thing. These are the 3 committees formed. One was Osin Kamallo Bulzar Burwa, one was Anima Azurika, and one was C.R. Sharma. So there was a lady was only one.
Yes.
So you therefore appeared before board number 2. Board number 2. What was her name?
Sandana Sharma. এইকেইটাটো এইটো পইণ্টৰ লাষ্টত ৰাখিছো permissibility of devising benchmark.
When did you attend the meeting? Of? And what about number three, election board number three? Twenty-nine January 2005. Selection board number two's last one is 13-2.
If logic finally takes up the index, one moment, index, yes. That index. Kindly see the serial number 10, 11, and 12.
In attendance sheet of the
9, 10,
candidate.
11, 12.
Okay. Take on the book number 12 to the serial number.
First election was conducted for PP, then additional PP, and then subsequently at serial number 11, it is for assistant PP in the month of January to April. And if it is board 2, then kindly take up.
Selection board number 1 is from 17/8/2024
17, that is
to
for PP.
23/8/2024.
He appeared for assistant, my lord.
That is for PP.
Now there are selection board 1, 2, and 3.
Yes, sir. 1, 2, and 3, first selection in the month of August to September, it was held for PP.
This is from 17/8. This is for 1.
Yes, Lordship, kindly take the number at the left corner.
And what is the, where is the number 3?
Kindly take up serial number 14C.
14C.
14C at the top left corner numbers are given.
14, mark sheet of assistant PP.
Yes, sir. Board 2. Yes.
Okay.
Top left corner.
29/1, na? Was the roll number 404068, na?
4068.
She's there. Then what is the problem with her? So what? No, your number is 54.13. No. It's there very much. Sandana Sharma. You were there. 33 you got out of 70. Then 15 out of 20. And 6.13 out of 10. 54. Your number is there. Maybe the verification was carried out initially, most probably with all the other people. Later on, it must have been done. This is very much here.
Page 57, you have said that
Huh?
for the post of assistant TP, the last selected person has got 60.96. At page 57. Police verification, the appointment or
6.13. You want the marks? Oh, very well. No, Mr. Chaudhary, I'm not convinced with your submission, but what I'll give you an opportunity to file an additional affidavit
Yes,
so that later on, when you raise the issue before the division bench, it may help you out. Otherwise, I'm not convinced with your argument, but otherwise tomorrow you may have one thing out there that you are not in a position to raise that ground in the appeal
Yes,
because of this.
yes. No, Millard,
Yes.
that part is absolutely your lordship's prerogative, Millard. It's my duty to just, I think.
It is also my duty to help you out to raise that, because this is again an issue which you can very well raise in the challenge to 19.2.
Yes,
Because the power which has been given to the selection
Yes.
board is without any what you call fetters.
now, for example, one aspect I may just indicate, Millard. The Constitution bench in Tej Prakash Pathak, what Supreme Court has said, Millard. Etu ase neki etu? 2025 to SCC page 1. At this point we have taken, Millard, but the other point we have not taken.
What is this?
Para 52. Ase neki?
Tell me. I remember.
It says, Millard, however, I'm just reading it, thus in our view, the appointing authority, recruiting authority, competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmark for different stages of recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before commencement of the recruitment process. But if the extent, rule or advertisement inviting applications empower competent authority to set benchmark at
But
different...
Mr. Chaudhary, again, the problem lies, this still 53 is prior to the selection.
52, Millard.
Understood? Till paragraph 53, it says about the prior to the selection.
No, Millard, it was in the context of whether Manjusri was correctly laid down or not. That why the reference was.
Yes. Now,
But
kindly
here
see-
it says, Millard, whenever
kindly
you set
see
any benchmark,
the
it
D.
must be made known. That I am on that point, Millard. But however, if any such benchmark is set, the same should be stipulated before commencement of the recruitment process.
Yes.
Now,
No,
where was it done in this case?
Therefore, my question here is different,
Yeah.
but here we have to go by 54.
Para 54.
54 is with the other heading. Now here, what happens? Therefore, you relied on 1997. Kindly see the other
95, Millard.
Yes, para 56.
Uh-huh.
Para 56.
In
And,
MP Public Service Commission.
yes, and down 4 line, it has been impressed by this court from time to time that when selections are made solely on the basis of interview, then such interview viva voce must be carried out in a thorough and scientific manner in order to arrive at a fair and satisfactory evaluation.
My lord,
of
I am
this.
not on this. I am not on the method. All that I am trying to emphasize is, my lord, they should notify it. If they do not notify, it would reach it. That is what, my lord, that Krishna Kanta Sahu's case.
Then why didn't you challenge that?
Because I came to know only after the affidavit was
No,
filed.
no, no. If you were not notified, you were prejudiced.
No,
You are prejudiced.
no, no.
You-
Yes, we are prejudiced.
You are prejudiced. So why didn't you notify immediately after the selection, waited for 5 months for that?
We didn't know anything only when the affidavit in
No, no,
opposition-
my question is after the interview was held,
Hmm.
why did you wait for 5 months?
My lord, we didn't know anything. Interview, we went there, we came back. Only when the affidavit was filed, we came to know that this was the procedure which was adopted. Only when the affidavit in opposition was filed. That is why, my lord, Madan Lal was distinguished on this point. When I place my argument, I'll go serially, my lord. I'll place everything.
No, you are on reply, Mr. Chaudhary.
Reply.
You are on reply.
I will reply.
You are on reply. You have to, I have to cut short of you on this.
Yes.
You are on reply. You are not again proponing out here your arguments again. That you are going to make further arguments.
Reply absolutely correct.
Yes.
And I will deal with the point of Madan Lal. Because state relied upon Madan Lal, I must say why Madan Lal is not applicable. I'm only saying that much.
So argue on that.
That I can do today.
Argue that.
Yes.
Today.
Only thing is the other point, Miller, I would like to file a short affidavit. On Madan Lal, I can argue, Miller. There is no difficulty.
Yes.
My lord, first judgment would be, my lord, our High Court judgment, Mumtaz Ali versus State of Assam and others. 2006 2 GLT 349. Yes. I'm only replying. I'm not trying to, my lord, restart again. 349. In fact, my lord, this was the point I asked before this honorable court. My lord, it is 2006 2 GLT 349. If your lordship will kindly come to page number para 14, my lord.
But is this not the judgment of Sadananda Oja?
Yes, eventually it led to Sadananda Hall.
So there, how can we take into, because Sadananda
No,
Oja
Sadananda
Sadananda Oja duly takes note of this aspect in his judgment.
No,
Can you have a look at it?
Sadananda Hall was on the point of, my lord, whether a roving and fishing inquiry can be.
No. There also they did relate. Kindly see. Hello. Only see this paragraph of Sadananda.
Sadananda Halloi was basically on, my lord, if I correctly understood it, my lord, it was basically on the point that unless there is a foundation laid, you cannot argue. In other words, there cannot be fishing and roving inquiry. I think paragraph 53 or something. But this
Yeah.
read
Para 59. Para 59 of Sadananda.
My lord, paragraph 16 of our High Court judgment, my lord.
No, para 59 of Hello,
Okay.
Sadananda. Because This aspect having been dealt with by the Supreme Court later on in the same set of litigations, I cannot rely on the single bench judgment.
Anyway, I'm not relying on our High Court judgment. I'll rely on Supreme Court.
Yes.
Please come to 1997 9 SCC 527.
Yes, Rajkumar.
Yes. Para 16.
That was the only saving grace to Madan Lal's problems.
No, my lord, there is another single judge judgment of our High Court where this was very.
No, I think
Succinctly.
the case in Abhisheka Chaturvati
Huh.
and subsequently the Jasmine score. What is that other judgment?
Meta.
No, this Karnavati Ravi.
Okay.
No, not Karnavati Ravi. Karnavati Ravi is not there. That is another one.
No.
This one. Salam Samarjit Singh. Salam Sarmajit Singh, the three judges bench, which I gave it to you on the last occasion. This is a three, you see there are
Right.
two judgments, three judges. Madan Lal is two judges.
Two judges.
Also, this Hello is two judges. All are two judges.
Rajkumar is a three judges.
Is a three judge. And other three judges are two. One is Muhammad Mustafa.
Hmm.
It's three judges, which duly takes care of this aspect. And the other one is this, which I just told you, Sadar Amarjit Singh. There was a Sadar Amarjit Singh, Salam Samarjit Singh. Salam Samarjit Singh was a three judge where there was a difference of opinion between Justice Siva Kirti Singh and Justice R. Bhanumati, which is reported in 2016 10 SCC 484, and thereupon in 2023 the other judgment came in. Anyways, let us see.
Yes,
Rajkumar.
Rajkumar Rashpati. My lord will kindly come to paragraph 16. Yet another circumstance is that government had not taken out the post from the purview of the board, but after the examinations were conducted under the 1955 rules and after the results were announced, it exercised the power under proviso to para 6 of 1970 notification, and the posts were taken out from the purview thereof. Thereafter, the selection committee was constituted for selection of the candidate. The entire procedure is also obviously illegal. It is true, as contended by Sri Madhava Reddy, that this court in Madan Lal and other decisions referred therein had held that candidate having taken a chance to appear in an interview and having remained unsuccessful cannot turn around and challenge their either the constitution of the selection board or the method of selection as being illegal. He is stopped to question the correctness of the selection. But in this case, the government have committed glaring illegalities in procedure to get the candidates for the examination under 55 rules. So also in the method of selection and exercise of power in taking out from the purview of the board and also conduct of the selection in accordance with the rule. Therefore, the principle of estoppel by conduct or acquiescence has no application to the facts of this case. Thus, we consider that the procedure offered under 1955 rules adopted by the government or the committee as well as the action taken by the government are not correct in law. So, my lord, once there is a error or, my lord, deficiencies in the procedure of selection, then, my lord, this bar of estoppel by participation will not come into play.
You come to this Sadananda Hello.
Yeah, hello.
Paragraph 59, that is relevant. You have the judgment?
We're getting it.
Now you take this. Paragraph 59, there is an exception carved out.
It is also settled position that unsuccessful candidates cannot turn back and assail the selection process. There are, of course, exceptions carved out by this court to the general rule. The proposition was reiterated by this court in the latest judgment of so and so. This was a case where different cutoff marks were fixed for unreserved candidate and scheduled caste and scheduled tribe. This court in para 10 of a judgment endorsed the action and recorded a finding that there was a power in the employer to fix cutoff mark, which power was neither denied nor disputed. And further, the cutoff marks were fixed on a rational basis and therefore no exception would be taken. The court also referred to the judgment is Om Prakash. This is the first case, in fact,
Yes.
1980,
Yeah.
where it has been held specifically that when a candidate appears in the examination without protest and subsequently is found to be not successful in the exam, the question of entering the petition challenging such examination would not arise. This court further observed in so and so. There is thus no doubt that while question of any estoppel by conduct would not arise in the contextual facts, but the law seems to be well settled that in the event the candidate appears at the interview and participates therein only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or there be some lacuna in the process. In para 22, this court further observed that there are certain exceptions to the aforementioned rule. However, court did not go into those exceptions since same was not material. And my lord, yes, it's a fact, my lord. Normally, if I participate, then I cannot turn around. But if I can show that there are infraction of the rules, if the procedure prescribed is not followed, if the procedure adopted is unfair, then certainly, my lord, there cannot be any estoppel. Because and in some of the judgments, Supreme Court says I will get to know only when I participate.
And more particularly in
That's
Abhishek
meta.
Huh?
Meta.
No, Abhishek Chaturvedi.
No, my lord. Dr. Meta Sahai.
Meta Saha is there, but this has then been by another 3 judges. Anyways, Meta Saha also says.
Yes,
so.
yes.
And this has been approved by in that
Yes.
Sadarmal Samarjit Singh.
Yes.
That's a 3 judges.
Yes.
This Meta Saha has been approved.
Yes. Now, my lord, if your lordship would kindly have the Meta Sahai for a moment, my lord. 2019, 20 SCC, page 17. Para 17. And
Yes.
okay. Para 12. My lord, in paragraph 12, that objection was taken that once you have participated, you cannot turn around. Now, if your lordship would kindly come to para 17 at page 26. However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not illegality in it. In a situation where a candidate alleges misconstruction of the statutory rule and discriminating consequences arising therefrom, the same cannot be condoned by merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he participates in the selection process. So, my lord.
Well, therefore, it says that by way of an estoppel, you cannot take away the rights
Right.
under Article 16.
Yes, Article 14 and 16.
6.
Correct.
There's no quarrel with that.
No, my lord, I think, my lord, it will all depend upon the facts of each case. Yes, my lord, supposing in a case where everything is all right, I have not been selected and therefore I am raising some issue. Yes, certainly, my lord, that initial case of 1980, that will apply with all vigors. There's no doubt about it. But in a case where, my lord, there are arguable cases where the decision taken by the, my lord, end of the day, when your lordship decides to take up a writ petition on the 226 side, my lord, because there is an element of public interest involved in it. That's why it is public law remedy. Therefore, my lord, on one hand, it is the upholding of the constitutional principles, and on the other hand, my lord, the government's action. Therefore, in those situations, my lord, this will come. My lord, in one judgment of our High Court, my lord, Madan Lal was explained, if your lordships would kindly permit me to place that. This is 2013 5 GLR 750. About 2013 5 GLR 750. Para 24. No, can't listen to see.
You don't have the first page?
Milord, just missed out, Milord. That's why, Milord. Para 24, it starts with the decision relied upon by the respondents.
We
In
don't
Madan-
know you keep this court in, who is the judge? Anyway.
No, no. No, Milord, what happens, Milord? My junior has developed a practice of missing out the initial parts, Milord. It's pretty long.
Anyway, just then.
Prayer 24, Milord, at page 213. The decision relied upon by the respondents in Madan Lal and others stands on a different factual foundation. It was a case relating to selection of a munsif in the state of Jammu and Kashmir by Jammu and Kashmir Public Service Commission. The selection comprised of written examination and viva voce test. A sitting judge of the Jammu and Kashmir High Court was part of the interview board which conducted the viva voce test. Petitioners in that case contended that they had fared well in the written test and also in the viva voce test, but the result in the viva voce test did not match their performance. So this was the case. So the prayer made was for quashing the viva voce test and to make the selection on the basis of written test alone, or in the alternative to conduct a fresh viva voce test to assess the merit of the candidate objectively. It was in that context that the apex court held that the petitioners took a chance to get themselves selected in an oral interview, and only because they did not emerge successful, they filed the writ petition. Facts of the present case are altogether different, as would be evident from the facts narrated above and from the discussions made in the succeeding paragraphs. In such circumstances, this court is of the view that the challenge made by the petitioner requires a determination on merit. So, my lord, there were the Madan Lal, the prayer was something, my lord, which
No, understood.
Yes.
But the thing is, if you see all these judgments,
yes, my lord.
even Mohammed Mustafa also,
Yes,
the court records and decides the preliminary issue,
yes, yes. Besides,
and then also decides on the question of merit,
yes, both.
both.
Yes,
But doesn't rest with only the preliminary issue and finishes it.
correct. My lord, if your lordships on this point, if your lordships would kindly take this judgment which I have referred already, 2024 13 SCC 432, my lord.
The Sukhmandar,
No, my lord, Nutan Kumari.
13 SSC.
Yes. If your lordships would kindly come to para 25. My lord, this was the view of the single judge of the High Court, which was upheld by the Supreme Court. Now, here also, my lord, in Placidum Z, apart from other aspects, my lord, this aspect was gone into. If in italics, my lord, if a person participates, page 442. Placidum Z, my lord, entire portion is in italics. If a person participates, has a lordship's got it, my lord.
Yes.
If a person participates in the selection process with his eyes open, knowing the selection process, then upon failure to get selected, he cannot turn around and challenge the same. He would be deemed to have acquiesced to the same. This is not at all a case in the present, as noted above. Nutan Kumari challenged the process even before the inquiry committee gave his report. Challenge cannot be said to be belated in any aspect of the matter. The criterion was not disclosed. It is only after criteria were disclosed, to some extent can it be said that person was in position to challenge. Same is the case here.
Same is not the case.
Yes. Milord, in the affidavit in opposition, they have come out with that case. Then only we got to know. Otherwise, Milord, we were interviewed.
You were present in the meeting out there. You had the interview out there. All these things were there.
No, my lord, when a person seeks job, my lord, he cannot go and question this selection authority. What
This
is
is
the
what the
procedure
Nutun
you are
Kumari did.
following?
This is
My
what
lord, they have posed some question, you have answered.
No, this is what Nutun Kumari did. Nutun Kumari, before the report being given by the expert committee, she immediately challenged.
No, true, my lord. But here also, my lord, the same is the position. But lordship will have to deal with this. The criterion was not disclosed. That is why, my lord, if your lordship should kindly come to para 27.1. The selection committee proceeded to fix the criterion for assigning marks to the candidate on the date of conducting the interviews. This said criteria was neither revealed in the advertisement nor disclosed to the candidate prior to or even at the time of conducting interview. This was the ground on which Milord selection was interfered by the single judge of the High Court and Division Bench, Milord, then eventually Supreme Court upheld. Para 28. In view of the above facts and circumstances, the learned single judge rightly concluded that the entire process adopted by the selection committee was vitiated and could not withstand judicial scrutiny.
Kindly come to 27.2. That
Yes.
might help you.
That though advertisement only laid down the eligibility criteria by virtue of qualification prescribed for inviting application from the applicants, the selection committee on its own fixed a total 100 marks and assigned different marks for different academic qualification, 10 marks for matriculation, 10 for intermediate and 40 for graduation. Same was done in our case also. Same procedure. My lord, on that I have a final argument, my lord, regarding that last two sentence of 19.2. There, my lord, I think the basic requirement has to be disclosed by the executive. Yes, if some gap is there, my lord, that can be filled up. And my lord, that 19.2 was followed. How do we know? Where is the material? Which is that judgment which is there? Which is that pleadings which was given by the particular candidate? Where are those? And they're supposed to, and as per the rules, they're supposed to preserve the records. They have not done it. They have not placed before this honorable court, at least to show in one case that here he succeeded because these are the pleadings and these are the judgment he has placed. Oh. And my lord, they should have made it a part of the application. Oh, tranke. And the contemporaneous records, if they do not produce, my lord, at the state will take the responsibility for it.
This is the entire set of selection procedure. This is it. You again produce it on the next day. Let me give you an opportunity. Mr. Ken Chaudhary, Delaware Senior Counsel, has submitted his reply arguments. During the course of the reply arguments, the learned senior counsel contended that either the rules, statutory rules framed under Article 309 of the Constitution, or by way of executive instructions issued under Section 70, Article 73 or Section Article 162. The criteria on the basis of which the selection proceedings are to be conducted had to be made by the rulemaking authority or the state. The selection committee on their own cannot devolve a criteria for selection without such provision being there in the rules or in the statutory instructions.
Or executive instructions.
Or executive instructions. Statutory and executive. This court finds it very pertinent to take note of that the said aspect have not been pleaded in the writ petition, and without a pleading to that effect, this court cannot accept such submissions, contentions, inasmuch as it would cause prejudice to the respondents. First, Mr. K. N. Chaudhary, the learned senior counsel, submits that he would file a short additional affidavit bringing on record the said additional pleadings, which would be filed within 5 days from today. First, considering the above, this court grants a liberty to the petitioner to file their additional pleadings on or before 27/2026. Liberty given to the state as well as the private respondents to file reply thereagainst on or before 27th of July 2026. List the matter on 28th of July 2026 for final disposal. Rest are complete.
Yes, yes, only on this point.
This I am allowing it only to have that if I'm wrong.
We are
No,
doing our-
only problem
we
is,
are doing our part.
no, Mr. Chaudhary, the only problem I have is this matter should have been there with 19.2. This argument would have been very much there in 19.2 when you are arguing that, look here, not only 19.2 gives everything on merits, on inter viva say, But also, it gives an unfettered jurisdiction upon upon selection board.
Discretion, yes. Correct, absolutely. That's one of the main principal ground why the rule is bad.
And
In fact, my lord, in that petition also, we have not taken that ground because we could discover this only the other day.
so you have to take this.
I
to
think
the
we'll have to
read
take
appeal.
there also.
No, you may not with the read appeal. Anyway, that is besides the point. Another aspect. That day I was just thinking it aloud. There are various, although you cannot raise that issue, Mr. Chaudhary,
Lord,
you may
instead of,
not able to raise this issue as you have participated, more particularly you being a public, you have been a public prosecutor. But these rules have been made and the arguments which have been made from the state shows that these PPs, additional PPs or assistant PPs have been reduced to the status of a government servant.
yes,
Wouldn't it be conflict with the various judgments of the Supreme Court
Yes,
which
yes.
states that the PP has to be an independent person?
the moment he draws salary, he becomes subordinate.
That is a thing which needs to be
No, correct,
pondered in
absolutely.
some other, not in these, you cannot, as a rule challenging you cannot, you have participated, you cannot. But anybody else, but think about it. This
Correct.
is a very important issue.
Correct.
Tomorrow, because we always expect the PP. The PP, there is one judgment where it says the PP's, what is the PP's role? The PP's role is not for the state. It is
Yes.
not for the, it is for the prosecution.
Yes.
There is a
It's an
difference
independent
between-
agency.
It's an independent agency.
My lord, instead of 29, could it be 31, my lord?
What?
Actually, I'll be in going on that. 31, my lord.
31, not postponed. 30.
30. Yes. Thank you. Oh. Deep.
Yes.
May
What
it
is
please,
this?
may it please your lordship? Lordship, I have filed affidavit in reply by respondent, filed by respondent 2. And along with, I have filed also an IA to impleading the party of, impleading GMDA as the party.
What are you challenging?
Matter is about, it is construction,
We have
lordship.
constructed one house, lordship, B plus 3 building. That the allegation is that there are some elevations, lordship.
Who
So
are you?
neighbor, lordship.
Yes, she is my neighbor, respondent 5.
How
I'm
is it affecting you?
Lordship, already GMC had inspected the construction. They took permission for Z plus 2 initially, but eventually they constructed the building Z plus 3. Already GMC had inspected and sent notice. They are not satisfied. They replied. Then they sent notice under 337(1) and 337 1 and 2. Lordship, it page number 32 and 37.
Then
Then Lordship, then I did some RTI and I came to know that GMDA also inspect the area where construction is going on, and then they found some illegality construction.
then
So I filed an IA as just simply that as GMDA as party. Today I
no,
have
no,
filed.
no. Why have you filed the writ petition?
They have, Lordship, if you kindly see the page number 37.
Yes.
Annexer G, Lordship, kindly say page number 31 first.
Where is your house? Where is your building?
Near my eastern side.
Yes. Lordship give us.
Today, madam, you are not on a no ball, huh? It may get dismissed.
No, Lordship, actually it is by our day, but I am trying to, I know that.
Today you are not on a no ball.
I know
You are
that you.
playing on the, you are opening batsman today. That's whom. Now,
So I'm a little
Continue.
bit nervous. I'm not.
Prior to second idea, prior.
how are you concerned? And why should between you and him or her, this court should interfere? You have any problem, go there before the civil court.
Lordship, exactly, that is the point, Lordship. We have stated that we have started our construction in the year 2008. So 2006 bylaw will be applicable. And their case is that as we have obtained permission in the year 2021, so that 2022 and 2015 bylaws will be applicable. But she being the owner of the plot of land, being a Lordship fourth grade employee, just to make sure that our building is constructed with the permission. So she applied online for G+2 building, and online permission was obtained. In fact, that is not the permission on the basis of which the building was constructed. Building was constructed in the year 2008, and I have submitted some money receipts also. And accordingly, GMC, Lordship, the deviations were met up by the GMC, they have accepted our fine amounts, Lordship.
Now,
And
show
now-
me your assessment register.
I
You
am-
must have assessed the building.
Lordship, I am not GMC, I am the private owner, Lordship.
Understood. You have assessed the building.
Lordship, that GMC has access, and thereafter they have imposed some fine.
You say that you constructed the building in 2008.
Yes, Lordship.
Very well.
I
You
have
have assessed-
started construction from 2008, and Lordship, slightly I am constructing from 2008 till now it is incomplete, Lordship.
Understood. So you had the permission of 2003.
No, Lordship, no permission was taken by the petitioner. For
Then-
that, the deviation amount was, fine was given by the petitioner, by the respondent. Lordship.
Lordship, in our affidavit in reply,
How can you be regularized
yes, Lordship,
without permission?
We have
Can it be
stated,
regularized?
we have stated, Lordship, in our affidavit in opposition that there were some deviations.
No, where is the question of deviation without a permission?
Lordship, there was no permission, but
So if there is no permission, the entire construction is bad.
Lordship, no formal partition was taken by the petitioner, a respondent. She
Formal
wa-
permission.
That was, yes, Lordship, that was
So
some shops were
therefore-
there.
Therefore, the question is, if you have no permission, then the construction is bad. How is the petitioner involved?
Petitioner is my neighbor. Lordship.
neighbor, I am.
Where's your neighbor? Annexure O, page 47. Where's your house?
Annexure P153 page number, Lordship. They have construct,
Annexure
annexure P153 page number.
E1.
They're supposed to lift at least,
Annexure
5 feet.
P1.
but they have it.
No, I'm not there. Where is your house? You are a grade 4
Yes,
and you're building a 3-story.
yes, Lordship. Since
No, no,
2008,
they should be demolished.
Lordship, annexure O page 46.
she's her son is also suffering from blood cancer,
So
Lordship.
what?
So with
It
bigger
does- I
amount
don't have
she's hurt,
sympathy.
Lordship.
My sympathy is not there with all these things.
Therefore, Lordship, we have, filed an IA just because GMDA, AV party, because they have regularized after so many conflict, they have regularized.
Who is the petitioner?
She's,
I am the petitioner.
You have filed a writ petition.
Yes.
Where is the question of IA?
Actually, Lordship, there are 4 parties, but we did RTI. After we did RTI, we came to know that GMDA had also inspected the places, constructed area, and they found some.
How are you suffering? How are you affected?
Because Lordship, they're supposed to lift, their construction is near my wall,
So-
boundary.
So what?
Annexure O page 47, there are,
That I've seen it.
yes, Lordship.
Page 47.
They should be left at least minimum 5 feet. But if,
So your house is the which one? The blue one?
yes, Lordship, the blue one is the Aditya glass shop in my compound behind my home is there.
Then, so there is a slight deviation on the left-hand side.
No slide.
Why you are not demolishing it? Demolish that small portion and finish
Not
it
sure.
off. Unnecessarily fighting out. Somebody is building a house, so it's okay.
Even though that Lordship, their reply to GMC, the GMC found that they are not satisfied. Then after they did regularize their construction
Chalo.
deviation.
Today the GMC council is not there. Okay.
He was there, he left.
On account of the council for the GMC not being present, the matter could not be, hearing of the matter could not be taken up. List this matter again on 15th of September 2026.
Lordship, let the IA and affidavit in reply came along with the writ petition.
You go to the registry and bring it.
Obliged.
That's it. What is this?
This is not freezing of account, my lord, on the basis of a complaint, my lord, from the cyber. Entire account has been freezed, my lord.
How much amount?
Initially, we got information regarding 62,384. And bank filed affidavit, my lord, saying that the amount is 2 lakh.
There are multiple freezing, my lord. There are 2,25,000,
25,000.
2,22,500,
How much?
2,22,500.
2,22,000. This amount? The details of the complaints are these?
No,
Yes, madam. The
Page
details of the
24.
complaint are as
Page
under.
24.
page 24, my lord.
Yes, madam.
These are the amounts.
These are the amounts.
Okay.
My
Don't
lord-
allow this.
Well,
Freeze it.
before going to this, well, I'd like to interrupt here. Well, on the last occasion, issue was raised, my lord, with regard to the maintainability of this petition, my lord.
Keep this on freeze till these authorities ask you not to allow you, keep these amounts of 2,22,500 under the freeze. Remaining, allow him to function.
Well, actually, I am the private bank, so. the
So
bank-
what?
my
So
money.
therefore, your problem is what? 2,22,500 is the amount. which
That
is
part
being
we agree, my lord.
So keep that. Don't allow this amount to be used. We keep this on freeze
My lord.
and allow him to otherwise function.
Lost. And
And in that regard, it was a table amount to. And therefore, are these people parties, authorities? No.
No, my lord.
So therefore, make it specific that unless informations are not received from, shall be kept on freeze till due informations are not received from these authorities.
Right.
Authorities, page 24 of the ask, the free. Dispose
Like-
of it.